Madam.
Huh?
Gauhati Gymkhana Club matter, madam. The connected writ petition is fixed today, madam. Deeply obliged.
May place rules. I beg to mention for listing, my lord. 2nd of March is the leftover matter. This was listed on 8/1, my lord. Till that is not listed.
Number 5.
May please. I beg to mention item number 44 and 45 supplementary list. But it may come up after 3 weeks. Lord.
Huh?
I have taken consent of.
The
After
last
3
two
weeks.
days, the Lordship was pleased to about the disciplinary petition and he had placed in order passed by Justice A.D. Chaudhary, Lordship. But the matters were listed today before your Lordship itself. The Lordship will come back, will be sitting singly then.
Now what is the one?
After 3 weeks. Lord. After 3 weeks.
After
3 weeks.
3 days.
3 weeks.
3 weeks.
Why?
Lordship, your Lordship is not willing to take up this matter in last time, Lord. So it may be come up.
I said what?
Your Lordship was about to dismiss the petition, then he has
No,
judgment passed by the Justice.
Similar order I have placed. Lord.
No. No adjournments.
Maybe sir. Lordship, I beg to mention for a listing a matter, Lordship. Matter related to, Lordship, Anganwadi Center Committee.
Vote number 5.
Maybe Lordship. My lord, I beg to mention item number 4, my lord. Mr. Pathak has some urgent medical difficulty, my lord. He is out of station, my lord. However, we have applied for the link also. We have also taken link yesterday, my lord. But he is not able to join through BC, my lord. So
What
this
do you want?
my lord,
What do you want?
next week, my lord.
Why?
Next week, my lord, Mr. Pathak will available and he will argue the matter, my lord.
Affidavits filed? Oh, fantastic. No adjournments. Next.
Please, your Lordship. Lordship, I beg to mention and repetition for listing for tomorrow, Lordship. Lordship, actually, another matter is listed tomorrow. Lordship, same matter.
Go and mention it there. Vote number 5.
Okay, Lordship.
Please, your lordship. Lordship, in item number 14, I'm seeking an adjournment just for the day, your lordship.
48.
14.
What do you want?
Lordship, Mr. D. Gogoi was the engaged counsel. He's indisposed today. I have also informed senior counsel, Mr. B.D. Gogoi, your lordship.
Who is indisposed?
D. Gogoi.
Mr. B. Gogoi.
D. Gogoi, your lordship. Dixit
Matter
Gogoi.
pertains to what?
Lordship, the facts is that the petitioner was running an industry in Arunachal Pradesh, but the access to that site, it falls, the road passes through a reserve forest. So there have been some issues regarding the transportation. Lordship. Affidavits have also been filed.
There's an interim order?
Yes, I think so, your lordship. No.
We will see when the matter reaches.
Obliged, lordship.
May it please, your Lordship. I beg to mention item number 12. 12, your Lordship.
What do you want?
1 to 12. Your Lordship, affidavit in reply filed by the petitioner yesterday. That may be called for in connection with item number 12. Lordship. Obliged.
May please, your lordship. Yes. Oh, this one. Did you file an additional affidavit?
No, my lord, I have got the original map, my lord. My lord, 27, and now can I just indicate, my lord, from time to time it has changed. My lord, in the year 1958, the DUG number was 25 co and Patta number was 26. Then in the year 1988, DUG number became 174 and Patta number became 60. Then, my lord, 2007-8, DUG number changed to 270 and Patta number is 5. That is how it stands today. And this 19, my lord, we do not know what is this 19. I am not in possession of any land belonging covered by Doug number 90.
So. Now, if this court is to decide that, then you have to put it on affidavit this aspect.
We'll file an affidavit, my lord.
You have to file an affidavit saying that this Doug number
Yes,
25 co-op, KP Pata number 26, how it became changed from time to
yes,
time.
my lord. That I,
And that
I've
will
got
be
the record
documented.
also, my lord. From time to, no, my lord, that's a handwritten note.
Hmm.
Initially it was 25K,
Hmm.
then Patta number was 26. 88, it became, Doug number became 174 and Patta number became 60. And 2007-8, it became 270 and 5.
Chapter number 5.
Yes.
So you need to bring on record, therefore,
Yes. All the three changes, Miller.
all these.
No,
three
no, one
changes.
is already there. The first one is already there because of the original deed, Miller.
No. So do you have the latest Jamabandi? Yeah, you have not enclosed that.
No, Miller.
So that was.
No,
because
Miller,
latest-
I asked the client to check from the circle office. From circle office, they got this information.
No, it's okay. So then they will have the latest Jamabandi.
How we can have the latest Jamabandi?
So therefore, we can say that you cannot interfere with this.
Mala, our
Doug
only
number
case is-
19, you go ahead.
Do whatever you
But
like.
whatever may be, but they cannot be disturbed in this.
That's all, Miller, because we are not in 19.
I also need to clarify whether this 270 by any chance, whether that is 19.
Related.
That is 19 at any point of time.
You find
Because
out.
in 2015, notice was issued in 2015. So maybe
No, in 2015, the Patta was 270. Sorry, Doug number was
no,
270.
that is what I have to clarify.
So
Because
you before.
That actually what had happened, Millard, let me explain one thing, Millard.
What
Then-
is happened? No, Mr. Chaudhary, actually, this is a question which should have been decided by under section 9, not by this court.
Millard,
Be that as it
purpose
may,
of-
as this matter has been pending for this.
Quite sometimes, Millard.
So therefore, we will look into this. You
Yes.
file an additional affidavit.
Yes, I'll do that.
And then I think we can look into it.
Yes.
Taking it as an exception,
Millard,
because I am otherwise very
interesting the
particular.
present state of Jamabandi.
Because you bring on the Jamabandi, the Chita copy will
Yes.
show how the land has changed.
Yes,
And have this revenue map also brought there.
yes. That's the original one. That's why I gave a
Mr.
photocopy of.
Mr. Kane Chaudhary, the learned senior counsel appearing on behalf of the petitioner, submits that in pursuance to the order passed by this court on 18/2/2026, inquiries were made by the petitioner, and he was instructed to apprise this court that Doug number 25K had been renumbered pursuant to various settlement operations from time to time. And presently, the Doug number 25 co-op KP Pata number 26 has been renumbered as KP Pata number 5 of Doug number 270.
Yes.
He has also been made, the learned senior counsel also submitted that revenue map is also available with him in that regard. It is the opinion of this court that the transition of Doug number 25K of KP Pata number 26 be brought on record by filing an additional affidavit, which will indicate the various changes eventually leading to the Pata number 5 of KP Pata number 5 of Doug number 270. In addition to that, the petitioner shall also bring on record the revenue map, as the same would aid in the adjudication of the present proceedings. Mr. Ken Chaudhary, the learned senior counsel, submits that the said affidavit would be filed within
2 weeks, like 2 weeks, Milord.
within 2 weeks. Taking into account the above, list this matter again on 11th, possible
March, Milord.
March.
Milord, could it be next week, Milord?
Hello.
21st, sorry.
This is
March,
not parted, na?
Milord, can it be on 16, Milord?
There's no parted, so it's okay.
Oh.
Okay.
16 Kumbar.
We listed again on
11th of March,
16th.
16.
16th of March 2026. Full stop.
Deep Lord.
Interim orders passed earlier shall continue in the next.
Deep Lord.
Mr. Chaudhary, I found one aspect. That day, one matter you were doing pertaining to that panchayat.
Yes, Milord.
I found what is actually the point by which in a panchayat, why you cannot. I was saying that what will happen to 129? You remember that day you were doing where Mr. H.R.A. Chaudhary was there.
Yes.
Although in that matter, I didn't look into it, but then again, I looked into it. And
Subsequent, in a subsequent.
how 129 and how 111 works. 129 works when you file an application, you file an election petition within 60 days. 111 works in terms with 111 1H, means as per the procedure prescribed. Now, in the case of Gaon Panchayat, which was a case, the procedure prescribed is in Rule 62. Now, if you see Rule 62(4)(b), it says, an information being available with the Gaon Panchayat secretary would be then forwarded to the block development officer. The block development officer then will forward to the DC through the chief executive officer of the Jila Parishad. So that's an information. Like Mr. H.R. Chaudhary, they wanted to be impleaded. They couldn't have been impleaded because they had no business out there. And it is, you see, another very important thing. While carrying out the proceedings pertaining to nomination and all, there is already a scrutiny by which they already look into 111.
Yes.
So therefore, they are finding something which was not suppressed or it's a case of fraud. So therefore, there is a more vetting which is required by
That is
these
why this
authorities.
provision has been
So the DC on its own cannot take it up. So I
So
think
there is
this is the only way how you can reconcile 111 with it.
With
Otherwise,
129.
if you see Punnaswamy,
Puluswamy.
that 1954 judgment, then Mohinder Singh Gill, these are all under 329B, which is akin to 129B. They always say that, you see, election proceedings or election petition is not a lease between two parties. It is a lease against wherein the constituency is vicariously
Involved.
So it is more like a,
Public.
the term used is, it is more like a
In rem.
collective litigation. The word used collective litigation by Justice
Not
Krishna
between the
Nayak.
two candidates.
No. Although it is, they decide amongst the two, but it is a collective. So you have to also consider that this, therefore, they have mandated that it is only in these things you can look into. You cannot look into many other things.
Actually, that's a very fundamental.
This is very fundamental because otherwise 111 is creating havoc.
Yes.
If you don't like some person,
remove
you
it.
just move the DC strikes you out.
Yes.
That
You have
means
been
that
elected by somebody else.
and DC thereupon, if this procedure is mandated, then the DC thereupon becomes more than the election tribunal.
Yes.
Then how do you reconcile 111 with 127?
So to follow the procedure prescribed. Correct.
Yes, what is this?
My lord, the matter pertains to the petitioner being his license being cancelled because a third party, namely that is respondent number 9, Ratan Boro, claimed that he is the actual beneficiary for the fair price shop. And eventually, the
What
entire-
right you have?
My lord,
What are you asking? To issue the license of agent to deal PDS item under so and so against the vacancy caused due to the death of the earlier agent Thaneswar Boro in pursuance to the letter dated so and so forthwith. What is this? Why should you get it?
my lord,
Is there anything by law? Can you get it?
my lord, here, the respondents themselves have were going to issue the license to this current petitioner. But because of the claim of the said respondent number 9, his process was halt, and after the entire writ which was filed by
Now who has the license?
now the license is presently with a person Ripen Basumatari.
Then how can you get another license?
It was given on the just for till the completion of the both the writs are over, are disposed of. Both the writs are disposed of. One which was filed by respondent number 9 and one which is filed by the current petitioner.
Now what happened to the respondent number 9?
Respondent number 9 has illegally claimed that he was supposed to get the license.
He has not got it.
He has not got it.
What happened to his writ?
My lord,
What happens to his writ?
it is disposed of.
That's disposed.
Yes.
Now this is there.
Yeah.
Now what is there?
Now the current, according to the affidavit of opposition filed by respondent number 9, the page number 48 says in the last para, if I may read, fourth line, third line, Ratan Boro now attached near Sri Ripen Basumatari has as a stopgap arrangement, just so that the people of the village don't be.
But how can this court direct that you should get it?
My lord, I was the first person who claimed that, as I was the nephew of the earlier person.
You are the?
I was the nephew. He was my uncle, Thaneshwar Boro, who was the original license
So
holder.
nephew gets it.
But the
It is
respondent,
hereditary. My question is. Then
my lord, but they
how
have
can
issued.
this go? Huh?
If I may,
Please, you are at liberty.
my lord, I have annexed documents starting from annexure 8, that is page 26.
Mr. Counsel, first show me where is your right.
My lord,
A right has to flow for this court to issue a writ.
absolutely.
I hope you are understanding what am I saying.
Yes.
There has to be a right. And when there is a right, there is a corresponding duty. And if they don't discharge the duty, this court can issue a writ, kindly do it. Isn't it? Isn't it the basic fundamentals of a mandamus? A duty imposed upon the authority is not being done, and you sought for it, and therefore not being done, you are asking this court to issue a writ. Isn't it?
Yes, ma'am.
Where is your right? That you should get it. Yes, Mr. Bhuya.
Yes, my lord. The article order, my lord, that license is not hereditary, my lord. It's not transferable. And apart from appellate authorities also there under the order, article order 1982. And so far with regard to the person concerned who have all these cards and all, my lord, as per the status quo order that has been given, my lord, whole of these card holder were attached to the near fair price shop, and it has been running that way, that manner, my lord. The rule doesn't say so, my lord. There is like right to transfer the license, my lord. There is no provisions.
You are Niranjan Boro.
Yes, my lord.
Yes.
Now, what is this 5/5/2015 document? This is a meeting
Yes, my lord.
where everybody has decided
Yes,
that it should be given to him.
yes.
And this is written by whom? The other one, executive member. By this way, it doesn't happen. Everybody has given it.
Absolutely, my lord.
That. Now, what is this 9/10/2015 document? This is by the Joint Secretary, Boroland Territorial Council.
And then ETC approve করেছিল।
Yes, what do you say on that?
That's what, my lord. Approval has been there, my lord.
Then why haven't you appointed him? And from the
Subsequently,
affidavit which appears,
Yes.
filed by the respondent number 4, he says that because of an order passed in another writ petition filed by respondent
Yes.
number 9, he has appointed him
Yes.
by passing a speaking order that look here, he should get it, without taking into consideration that there was a status quo order passed in the present writ petition.
Yes.
Now this has happened. So what needs to be done is there has to be an appointment to that.
Yes,
You have
ma'am.
to take this.
That's true,
So
my lord.
you take a decision and appoint whoever
my
it
lord.
is.
Let it be disposed of.
And take the case of the petitioner as well as the respondent number 1 and then proceed.
My
Proceed.
lord, if I may, respondent number 9 his license has been already cancelled. If they
The license has not been issued to him.
License has been cancelled because earlier, on the basis of the earlier order passed by Justice Suman Shyam,
Yes.
directing his representation to be considered, he was given the license. Later on, when they found out that there was a status quo order, therefore it was cancelled.
Cancelled.
But the fact remains that you are a contender along with Ratan Boro.
yes,
So therefore, both of you, I cannot say that you should be considered. Let them take a decision and consider and fill up the post. That's all. That's all law.
Let
They
it be
cannot
disposed.
direct that you should be appointed.
My lord.
There is no right. You see, you may have a right of consideration. You don't have a right to right of appointment or right to a license.
License.
Lekho heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. A.K. Bhuya, the learned senior standing counsel of the Bodoland Territorial Council appears on behalf of the respondent numbers 1, 2, 3, 4, 7, 8. Mr. N. Goswami appears on behalf. Who wants? You want your appearance? Okay. Miss Udas appears on behalf of the respondent number 5, 6, 5, 6, 8. You cannot. Now, the circle officer under them? No, you. Under DC. Okay, 8. Ito bodlai. And anybody for Roton Borough? Okay, none appears on behalf of the respondent number 9. The petitioner has approached this court seeking a direction upon the concerned respondent authorities to issue the license to the petitioner as agent to deal with PDS items under the Pochim Defali BSS Limited in pursuance to the letters dated 9/10/2015 and 28/10/2015. This court have perused the materials on record, and from the materials on record, it is seen that in respect to Pochim Defali BSS Limited, an agent namely Hanneswar Boro, brackets since deceased, was appointed to deal with PDS items. The said late Thaneswar Boro expired on 28/3/2015. The records further reveal that in the meantime, there were various resolutions being adopted by the general public and various recommendations also made favoring the petitioner to be to be issued the license to deal with PDS items in respect to the shop Pochim Defali BSS Limited. It is also pertinent to take note of that pursuant to these resolutions as well as recommendations, the Joint Secretary to the Joint Secretary Bodoland Territorial Council by the communication dated 9/10/2015 to the Council Head of the Department approved that the petitioner should be appointed as agent to deal with PDS items under the Pochim Defali BSS Limited. The records further reveals that the Council Head of the Department Food, Civil Supplies and Consumer Affairs BTC Kokraja had also informed the Superintendent Food, Civil Supplies and Consumer Affairs Tamulpur to appoint new agents referring to the communication dated 9/10/2015. It is also seen that the Superintendent, Food, Civil Supplies and Consumer Affairs, BTC Tamulpur, have also written a letter to the Postmaster, Tamulpur, pertaining issuance of the NSC in favor of the petitioner. While the aforesaid proceedings were going on to appoint the petitioner as a licensed agent to deal with PDS items in respect to so and so limited, the respondent number 9 had also submitted a representation on 2/6/2015 before the competent authority for consideration of his case also for issuance of license in respect to so and so limited. The non-consideration of the license led the petition respondent number 9 to file a writ petition being WPC number 6568/2015. The learned coordinate bench, by an order dated 16/10/2015, disposed of the said writ petition with a direction to the respondent authorities to consider the representation and to dispose of by passing a speaking order. It so happened that in pursuance to the order passed by this court by the learned coordinate bench dated 16/10/2015 in WPC number 6568/2015, the respondent number 9 was issued the license. However, the materials on record also show that prior to the issuance of license, this court had passed a status quo order on 29/1/2016. This aspect came to light. This aspect having come to light, and this aspect the status quo order, which when it came to the information of the respondent number 4, the license which was issued to the respondent number 9 was cancelled. In the backdrop of the above facts, the question therefore arises before this court as to whether this court can issue a writ upon the respondent authorities to issue the license to the petitioner on the basis of the communications dated 9/10/2015 as well as 28/10/2015. It is the opinion of this court that this court, in exercise of the powers under judicial review, cannot act as an appellate authority over the respondent authorities who have the right to appoint license agents by issuance of license. It is only when any arbitrariness or unreasonableness occurs in the decision-making process, this court can exercise the jurisdiction of judicial review. Considering the above, this court is of the opinion that this is not a case wherein this court can pass directions upon the respondent authorities to to issue the license to the petitioner. This court also heard Mr. A.K. Bhuya and on the aspect as to how A2 Limited is being presently run, taking into account that the writ petition is of the year 2016, and as per the affidavit filed by the respondent number 4, the license which was issued to the respondent number 9 was cancelled. The learned counsel appearing on behalf of the BTC submitted that in view of the interim order passed by this court, no fresh licensee license, no fresh agents have been appointed, and the persons who were tagged along to this so and so limited was tagged with another. What is that?
That is the another licensee vendor.
Another
Nearby-
licensee,
Yes.
namely,
Namely Pachim Defi BSS Limited, my lord.
same.
Yes.
It is the same.
No. This commodity to so and so benefit, the card holder attached to this fair share have been tagged with a beneficiary FPS dealer. PS dealer.
Considering the above, the instant with petition stands therefore disposed of with the following observations and directions. Number one, this court would not like to pass any direction in the present proceedings, thereby directing the respondent authorities to appoint the petitioner as the license agent of so and so limited. Number two, taking into account that in the meantime, no license agents have been appointed in respect to so and so limited. This court directs the respondent authorities to consider the case of the petitioner along with the respondent number 9 and other eligible candidates who can be issued the PDS license, the license to deal with PDS items in so and so limited, taking into account that tagging the consumers to another dealer is not in the spirit of the Food Securities Act 19/2000 ki baik ho. Mr. Bhuya, the learned counsel, senior standing counsel, appearing on behalf of the respondent, submits that the same would done expeditiously. Taking into account the above, this court directs the concerned respondent authorities to do the same within a period of 3 months from the date of the present order.
Deeply obliged.
Interim order so past tense vacate.
May it please, Your Lordship. Lord, we have challenged the validity of an award passed by the Labour Court, my Lord. Actually, my Lord, it is the respondent number 3 who is responsible for implementing the award. As such, we are not questioning the award on its merit. Our only perspective is that there was a business transfer agreement in terms of which, my Lord, the entire establishment was sold to respondent number 3. Now, if your lordships would kindly take, my Lord, page
Which
20
award?
Award, my Lord.
Award?
Passed by the Labour Court.
Labour Court.
Honey?
My Lord.
Honey?
No, Gauhati. Gauhati Labour.
Gauhati.
Okay, I see at 154.
No, my Lord, those are the 2 awards passed by the Thane Court consistent with the, my Lord, business transfer agreement. That's why we annexed those.
Okay, where?
Award is at page number, operative portion is 127, my Lord.
Okay.
It was directed to be reinstated with back wages.
Management of so and so
Page 127, my Lord.
was justified in dismissing so and so, so and so, so and so, if not so and so. Okay. What is the basis on which the decision was given?
Yes, my Lord, the business transfer agreement is at page 25. Now, if your lordships would kindly come to page number 31, my Lord. Business, it starts at page 25. Viadit Metallics is the petitioner, my Lord, and Supermax Personal Care Private Limited is respondent number 3.
Now, who dismissed these people? These workmen, who dismissed it?
Initially, we.
Then?
No, my Lord, at the time of transfer of this business from petitioner to respondent number 3, this litigation was pending. So, in the agreement, a provision was made that they would take over the liability.
You.
Respondent number 3. That's what I was trying to show, my lord.
Okay. In the disclosure letter, it is written, the present dispute has been mentioned in the disclosure letter between the parties, between petitioner and the respondent number 3. But there are clauses in the BTA, business transfer agreement, which shows that the respondent number 3 would be liable for the employees on the transfer date, wherein the employees were terminated on 5th of March 2008. And thereafter, the reference was made before the Labour Court on 2/5/2009. That is before the business transfer.
Now, Mr. Chaudhary, did you
My lord, let
raise,
me explain
did
the
you
issue.
raise that issue before the Labour Court?
No.
Then?
We are not there. We were not there, my lord.
You,
It
what
was
is your
respondent
name?
number 3 who pursued.
No, what is your name?
Vidyut Metallics.
But they were there.
No, my lord, after the transfer, we never appeared, my lord. It was the respondent number 3 who contested. Before
No,
that,
no, the management of AR.
let me place two facts, my lord.
Yes.
Please come to, my lord, page number 55. It's a part of the business transfer agreement, my lord. Now, VMPL, that is Vidyut Metallics Private Limited disclosure summary. Please come to the second column, my lord.
You are Vidyut Metallic.
Yes. 2. Save and accept as disclosed in the disclosure letter. The last accounts, insofar as they relate to the business, fully disclose all assets and make full reserve against all assets and fully provide for crystallized liabilities, whether or not quantify the disputed, and fully provide for all contingent liabilities, all outstanding capital commitments, and all bad or doubtful debts of the transferor on the last accounts date. Now, on the right hand side, my lord, all accounted liabilities are listed in
All
schedule.
unaccounted.
Unaccounted liabilities are listed in schedule 10. We are not concerned. All the contingent liabilities are enumerated in schedule 2, 3, and 4. Now, schedule 3, my lord, it starts at page number. No, I got it. My lord, schedule 3 starts at page number 71, my lord.
Yes.
Then, if your lordships will kindly come to page 72. Schedule 4, VMPL contingent litigation liabilities. Then at my lord, page number 74, serial number 72. Application number 6 of 2009, that is Labour Code Gauhati matter, Center for Medical and Sales Representatives as the union, 14,25,000. How can they dispute all these things, Miller?
No, so therefore, the fight is between you and him.
Correct.
He is not there.
I am the workman.
He is the workman, my lord. He is required to be reinstated with back wages.
So, who has the business been transferred? Where is the business transfer?
This is the agreement. I have read, my lord. It starts at page number 25.
No. This is not this. Where is the agreement? This is a.
No, this is the agreement, my
No,
lord.
this is a disclosure summary.
No, this is the agreement. It starts at page 25.
Page 25.
Yes.
Business transfer
Agreement between Vidyut Metallics Private Limited and Supermax.
You are Supermax.
Yes.
Now let us see. This happened when? Mr. Chaudhary, it is not
2007.
visible. You read
10.
it. Page 27. What is the date?
30/12/2010, Miller.
13. 38.
30.
38.
Day of October.
2000. Very difficult.
It should be December, Miller. 30/12/2010.
10.
10.
Now show me the clause by which the transfer happens.
Yes.
Disclosure letter shall mean the letter from the transferor to the transferee in relation to
to the
transferors
transfer of
warranties
warranties
accept and
executed and
delivered
delivered
immediately
immediately
before the execution of this agreement
in
in
the
the
agreed form
agreed form
together
together
with
with
the disclosure
disclosure
data.
data.
Disclosure data are those, Miller.
But they, as per that schedule, they were only liable for 14,25,000
Contingent. That was the contingent. Yes.
contingent, but they were not liable for re-employment.
Ha.
That is your look.
So, my lord, once he has taken over, he'll get, my lord,
That is your lookout. That is not a part of the transfer.
oh, my lord.
So you should have therefore said it before the tribunal at that point of time in 2014. This happened in 2010.
No, actually, my lord, since the entire thing was transferred, my lord, they don't dispute. Kindly see the affidavit in reply.
No, there's no question of disputing.
Huh.
The question is,
Yes.
this happened, this document as per the definition of disclosure statement
Yes.
is prior to the agreement.
Yes.
So the agreement happened on 30/12/2010.
10.
So this happened prior to that. Now in the disclosure statement, in so far as the present dispute is concerned, their contingent liability is 14,25,000. But how do you take care as regards the reappointment unless you brought this to the notice of the authority? Because the labor court was not brought, this notice was not brought to the notice, this aspect was not brought to the notice of the labor court.
Therefore, my lord, my humble submission would be, now it is the obligation of respondent number 3 to carry out the order of the labor court. How can, when they taken over the business, how
So
can they
therefore
say?
you show me how the transfer has happened.
Yes. Then I have to read some of the clauses, my lord.
Sale purchase, here, 2.1. The parties hereby agree that upon fulfillment of the condition precedents set forth in Article 5 and on reliance upon the transferor's warranties and so, and the transfer when set forth, the transferor agrees to sell, assign and transfer, and the transferee agrees to purchase, acquire, assume and accept the business as a going concern on a slump sale basis
Yes.
with effect from the transfer date,
Yes.
free from all encumbrances
Yes.
other than disclosed in the disclosure letter,
Yes.
and the transferee agrees to pay the consideration to the transferor.
Yes.
So what is disclosed is only he's taking which is disclosed,
Yes.
and disclosed is 14,25,000.
Yes.
But how do you take care of this person?
No, my lord, end of the day, it was a contingent liability and liability which will happen on a future date.
But that is not the disclosure.
No, my lord, disclosure, the disclosure data includes this litigation. So whatever is the outcome of the litigation, that they will have to bear. And which they did not dispute, my lord. They filed the affidavit in this proceeding. Now they say because a IBC proceeding is going on, therefore whatever claim he has, he should lay it before the IRP.
IBC of what?
Yes.
Insolvency against the respondent number 3.
Huh?
Filed order dated 11/1/2000.
You respond number 3.
Yes.
There's a IBC proceeding.
Yes.
Section 7. Has
So
been
there is a
already
moratorium
initiated.
also.
Going on.
Then how can this be let to do?
Okay. Section 14, view of section 14.
I can proceed with
Yes,
it.
Lordship, my submission is that.
You are the petitioner.
That is the prayer portion, Lordship. Prayer
What is the
portion
prayer?
of the. Because my submission is that
Section heading.
respondent number 3 is not at all responsible to make a payment to me. Because it is the Vidyut Metallic, they are the management, and it is the prayer is the Lordship. In the prayer, they have paid to set aside the award.
Award cannot be set aside.
And
Award cannot be set aside. Award remains as it is. Unless he goes into the question that the award is wrong.
no, my submission is that.
Award is right.
Award is right, all right. When
Now the
the,
question is the fight between who is going to bear the responsibility to implement. Now have you moved an application before the labor court?
yes, under section 33C2 for computation of the amount, and that has been stayed on that prayer.
Oh, we vacate that. You go ahead and put these people, the
Lordship,
directors behind me.
Lordship, my apprehension is that if my legal entitlement is not properly decided, because I am a workman, it will give a multiple litigation and ultimately I will suffer. Because if the first question is that the amount which they have, the learned senior counsel mentioned 14 lakhs, it was mentioned in 2010. At that time, the process was going on in the labor court of Gauhati. That my legal entitlement was under the consideration of the labor court of Gauhati, and it is decided in the year of 2014 also only. Thereafter, I have filed to calculate the exact amount. But during pendency of the petition, that is the reference, they have how they can decide that I am entitled to receive a 14 lakhs. It is the first issue. And
I'm not on that. Whatever they do, that's a different thing. You go ahead and do whatever is necessary before the labor
Sir,
court.
Lordship, on another issue is that
Why do you want this court to decide? You are not the petitioner here.
yes,
You
I am
have a
not
proceedings,
my
you have a proceedings pending. You can very well initiate a proceedings pending for the purpose of arrest of these people. Go ahead. There cannot be a stay to the award.
no, award is state.
No, we vacate that. Where is it? Where is the stay without expressing? Where is the award being stayed?
Award, that is the, yes, section,
Which order?
it is in the
33C2 proceeding was stayed,
proceedings
Miller.
state.
Huh?
33C2 proceeding was stayed, Miller.
Without expressing an opinion on the submissions made by these of the view, the records would be required to peruse. This court have also noted that Supermax has made on 3 until now, the supervision now in view of the year directs the others in view of the month. Next day, 37 should be released. So where is the stay? No stay.
Stay. In the view of interim proceedings, case number 1 of the 2022 and case number 2 of 2022, section 33C2 of the Industrial Dispute Act 1947 pending before the learned labor court Gauhati shall remain state.
Which one?
Uh,
Which order? Order is dated
3/5/2023.
P5.
Yes, they-
P5
The
2020.
first day, I noticed.
Huh?
It was passed in the motion dates. First day.
Where is the stay?
3523, Miller.
23.
Yeah.
Okay. Okay, we vacate this stay.
Lordship, I have one more submission.
Go ahead.
So basically, Lordship, the BTA, which was not placed
You
before
have
the
an
level-
IA.
Lordship,
You have filed an IA for vacating.
No,
no,
What is this IA? 1340?
no,
17B.
it is 17B.
17B. Who is going to pay that? Tell me.
My understanding is that it is the read petitioner. Read petitioner.
This petitioner doesn't have the business out there.
It is their submission, but Lordship, that they are relying on the business trade agreement.
Understood, but they have already transferred it to them. There is no quarrel with that.
Lordship, yes, page number 38, kindly peruse. 515. The transfer is not automatic, that there is a process. They are telling that we will we will issue a offer letter. And if the employee give consent, only then we will take the responsibilities. Page number 38, clause
Of?
515, 516
Page 38 of what?
of the read petition.
Where?
Clause 515. The transferor having procured the consent of such of each employees in the agreed firm in connection with the transfer of their employment from the transfer to the transferee with the effect from the transfer date. The transferee shall have issued to each employee an offer letter in the agreed firm, and such offer letter shall have been accepted by each employer, each employees.
Mr. Chaudhary, where is the provision
Yes,
whereby they take all your employees? When you're transferring it, the
Yes.
transfer also includes the transfer of the employees?
yes, Miller.
Where is the provision?
Sale and purchase.
Clause 1.1.16 Lordship, page 31.
1.1.1 employees shall mean the permanent employees who are engaged by the transfer in connection with the business, the list of which is set
Yes.
out in Annexure B. What is the list?
Permanent employees were engaged by the transferor in connection with business. 1.1.16. Annexure B2 for this. Huh? Annexure B2. ठीक है सर 6. Annexure B, हाँ. Sir, B2 code. Huh? Yeah.
Let's see the IBC about.
Section 14, Miller. Moratorium.
And when did the matter went to the DRT, the NCLT?
NCLT, the order was passed on 11/1/2024. The order is attached to our
2024.
24 Miller. 11/1/2024.
So today, as of now, it cannot be under such a resolution process. It must have gone to liquidation.
No, Lordship, it is still there. It
How?
has been continued by, it has been continued, Lordship.
Isn't it the mandate of 270 days?
Lordship, but it has been continued by the order dated 5/1/2026 for another 90 days.
Then also it is over.
No, my lord, for 90 days, till April, month. 5/1.
First week of April.
First week of April.
Has their claims been taken up there?
No, Lordship. Lordship, in the, before, the annexure 11 and 12, which my learned senior has been referring to, we were a party to that proceedings and the BTA was considered there. And in the present impugned order, Lordship, the Labour Courts Award, about the BTA, there was no mention, and the proceedings was conducted by the management of the petitioner company, not by us. The impugned award. And even if your Lordship decides that the respondent.
But you were aware of it. That this happened in 2010.
This is the Millard exhibit before the Labour Court, Millard, this business transfer agreement. Their document, Millard.
That is the.
Millard, the problem is, Millard, they file a execution petition against respondent number 3. Then, Millard, they file an objection where they made a wrong statement. Then they withdrew the execution petition. They filed execution against respondent number 3. He also knew. Millard, my humble submission is best thing would be let Labour Court decide who is liable. Let all the parties appear before that, and he's a workman, he should not suffer.
No, not only that. My more worry is because of the IBC proceedings.
Yes.
If his claim is not there,
Ah.
then as per priority, he would not be in the he has a priority.
Therefore, he should lay his claim before the IBC Miller. In fact, to which Miller respondent number 3 has filed an affidavit. He said now they should approach the IBC, NCLT.
Under section 65, 60 subclause 5 of the Act.
We do one thing, we vacate the stay. Yeah. One, and give you the liberty to approach the IBC. The reason why I'm saying so, if you don't, in the meantime, the certificate resolution happens, you'll be affected.
You'll miss the bus.
You'll miss the bus. It is there till April. So today I pass an order, you go there. One. As regards this, I vacate it, the labor court. You proceed there, whatever may be. But in that case, you approach there and make your claim. Because you all have a claim which has a priority in terms of section 54 of the IBC Act. So you go, this will be.
You'll get the
54.
money, Miller.
So you'll get your money or whatever may be, or how the transfer may happen, that they will be looking into it. You may be given a reduced amount or whatever amount, whatever may be your claims, you will have to lay your claims. Because if you lay your claims now within 270 days, if it is not liquidated, if it doesn't go for
Winding up.
No, not winding up. It's a certificate resolution. Doesn't happen. They will go for liquidation. If they go for liquidation, your thing would not be considered. And once it is liquidated, it goes outside your hand, my hand, every hand.
Lordship, one issue is that the amount which I shall claim,
You quantify it. And you have already filed an application before the labor court for quantification. Let that go ahead. Therefore, I'm allowing that to go ahead, but you quantify and lay your claim. And then they will look into it.
Milord, my only submission is, Milord, in the execution proceeding, let R3 be also a party.
That I cannot do.
I think
It is beyond
or else
me.
we'll get in ourselves implemented.
Because it is beyond me to do that.
Right.
So therefore, you do that. Let me pass that order.
one more, Lordship, it is for my own knowledge. Suppose that earlier they were the respondent under section 33C2, but after passing the order, their rule, they will not have any rule.
Eh?
But after passing the order by this court,
No, you are not. Court will permit them to go ahead.
I'm permitting that labor court to go ahead.
Lordship.
It is what I'm saying. Secondly, I'm allowing you to move the IBC because now they have a claim. The fact that there has been a transfer is there. There's an issue out there which needs to be adjudicated later on. Because tomorrow, what happened, the main problem which I see is this. They say the definition of employees are there, which is in Annexure B. Your name was not there. But the fact remains that that litigation was already there mentioned, which had the effect of a reinstatement. So therefore, when they take over the business, they have to do that also. They cannot say, because when it is there in Schedule D, they must be aware about this particular. And they had appeared before that tribunal.
Yes.
So when they have appeared before the labor court.
Kune? No, they. Now kindly have a look at this, Miller. I think the original record is there, Miller. Exhibit M, Miller.
M.
Yes.
M is different. Entitlement of domestic trade.
Page 51 of the record.
General conduct, Supermax.
Supermax.
General Code of Conduct, Corporate Office. Why is it?
It's of Supermax, Miller. Respondent number 3.
The evidence was filed in 2011, Lordship, at that point of.
After the BTN.
After the.
Who is Subhash Datta Chaudhary?
He's a director.
Your person.
He's a director of the Vidyut Metallic.
Initially, he was a director with us, initially.
Then,
Then my lord, thereafter he
was he transferred?
And he appeared before the labor court in the year of 2014, where he admitted that he is an employee of the.
My lord, all this problem has arisen because, my lord, they did not produce the BTA agreement. Everybody knew that there is a transfer, my lord. With bona fide, it did not appear, my lord. For a moment, that's why we are not challenging the, my lord, award that way. All that we are saying is, are we still liable after the transfer of the business? In fact, my lord, only on 2017 we came to know about the award, when we immediately wrote to them, my lord, labor officer.
Like these matters should have been dealt with very urgently.
Hmm.
Who is Suman Sarkar?
He is also director. No?
Huh?
He is also director.
Of,
Sorry.
was Suman Sarkar appointed by them at any point of time? Huh? Is he an employee?
Employee.
Suman Sarkar. Because he's the person who has adduced evidence on behalf of them. And because this was evidence was adduced in the year 2012. But was he your employee? Then if you was your employee at that point of time, it will be deemed that you have knowledge. This was evidence on affidavit filed on 25th. Let us see, I am an employee of Vidyut and presently I'm on Wellborn Retails Limited, Private Limited. Oh, this is different. This Suman Chakraborty was earlier employee of Vidyut Metallic Private Limited and presently I'm working as Wellborn Retails Private Limited. So it's not Supermax.
Well,
Sanjay Kumar Dhar.
My lord, if your lordship would kindly come to page 132, that's the execution proceeding, my lord. This was an application filed by respondent number 3, my lord. If your lordship would kindly come to 137, my lord. At 132, the objection filed by the respondent of the petition. 132. This was in the execution proceeding. A review application was filed, my lord, where they filed the objection. If your lordship would kindly come to 137, para 10. Last 5 sentence, my lord. Moreover, in Schedule 4 of the said disclosure, under heading VMPL contingent litigation liabilities, there is a specific mention of reference case number so-and-so at serial number 72, wherein it is clearly shown that the contingent liability arising out of reference case, along with other various cases, are of Vidyut Metallics and will not be upon the petitioner. Because of this statement, my lord, they withdrew the execution petition filed against respondent number 3. This is an absolutely wrong statement, my lord. Other from that said clause, it becomes clearly evident to the extent of the amount mentioned therein, they are liable. Because of this, my lord, this
And who has filed this execution petition?
he
Where?
union.
Union lordship.
Why are you filing it before the district judge?
No, it is the,
Huh?
because it was transferred. Probably I'm not aware because I was not the conducting counsel. Probably the system is that first they file labor
Well,
code,
under
then
section 11 of the act, I think the labor code
has
commits it to the
transferred.
district judge.
Transferred.
You don't have a labor code nowadays.
Commit the same to the executive court is the district judge. The award of the labor code will be executed by the After this, my lord, he filed the petition under 33C2 after withdrawal. Ah. Well, it's subsection 10 of section 11 of the
You have withdrawn with the liberty to file. Go and file it properly now. Make both of them parties.
Okay. Okay.
You see page 150 of whosoever petition. This is 32C.
I think, my lord, best course would be to file an execution case afresh, where they should make both of us parties, then will executing court will take a call.
And that has been filed in the labor code, Lordship, under section 33C2.
It is.
No, that is the Lordship. The process is that.
No.
That-
Mr. Mujumdar. 33C2 is for ascertaining the
Yes.
liability.
Yes.
That is another thing.
Yes.
For ascertaining when, just for example, the court says out there, they'll be entitled to back wages.
What is the back?
Then you don't know the back wages. You may ask for, then you will ask the court and file an application that, look here, you want to file a back wages, this is this, I am entitled, this was my salary at that point of time. A notice would be again issued to the company or the management out there, and thereupon the court will ascertain what is the back wages. And thereupon it will go for execution.
Yes, Lord. This is the process.
This is the execution.
Yeah.
So therefore, going out there to the execution is wrong then. Now,
Yes,
therefore,
earlier
you need to,
download.
you therefore need to amend 33C2. Taking into account these, I give you the liberty. The 32C2, which is there, the stay which was granted will vacate it, and thereby directly allowing to file appropriate application against him, and also him also, for ascertaining the liability. In the meantime, as he has submitted that there is an IBC proceeding, I give you the liberty to move it there and move an application out there, because he otherwise has no business today. Are you appearing for whom? Who is it?
Professional. The professional IRP.
You are appearing for the IRP. Oh, very good. You are not appearing for that company. Ah.
The affidavit has been filed by the IRP.
IRP. So therefore, he has to take, then I can very well direct you.
Under section 65.
Take him also into consideration. Very well. He need not go to the IBC. I direct you to look into it.
5 of the IBC.
What is that?
Lordship, notwithstanding anything to the contrary contained in any other laws from time being in force, the NCLT shall have jurisdiction to entertain or dispose of any application or proceedings by or against the corporate debtor. In case the respondent number 3 or a corporate person, any claim made by or against the corporate debtor or corporate person, including claims by or against any of his subsidiaries situated in India, any question of priorities or any question of law or facts arising out of.
No, that will happen later on. This will happen later on when you have made the resolution. The resolution has to be made. When the resolution is put to the NCLT, there is the scope of objections to be filed, and all these things the NCLT will look into. I'm not on that. But you are the interim resolution professional. So you therefore have to look into this action also. Because you cannot do it only for those banks. You have to also take his thing into consideration.
He's
Then
also a
it's all-
creditor that way.
Huh?
That way, he's also a creditor.
He's a creditor having a priority.
Yes, right.
Okay.
Lordship, one more submission that the.
No more.
Under section 33C, petition is pending and they are the party, so I can implement them.
Yes.
You do whatever you feel like, which I am giving you. Heard Mr. K. N. Chaudhary, the learned senior counsel, assisted by so and so, appearing on behalf of the petitioner. Mr. L.R. Mujumdar, FFZ Mujumdar,
With your lordship's kind permission, can I take deep?
appears on behalf of the respondent number 4 and 5.
4 and 5.
Full stop. Mr. M. Sahewala appears for the interim resolution professional who have been appointed by the National Company Law Tribunal, Gauhati, Mumbai. In respect to the respondent number 3, pursuant to a proceedings initiated under the Insolvency and Bankruptcy Code 2016. Mr. Kane Chaudhary, the learned senior counsel at the outset, submits that though there is a challenge to the award dated 28/1/2014, passed by the Learned Labour Court of Assam at Gauhati in reference case number 6/2009. But essentially, the challenge to the award is as to who would have to implement the directions so passed, the recommendations so made in the award, the directions so passed in the award. Taking into account that the business transfer agreement entered into by and between the petitioner and the respondent number 3, there was a clear disclosure as regards the pendency of the reference case number 6/2009 in Annexure D, appendix or annexure? Annexure D. D or D? In schedule 4 of, huh? In schedule 4 of the of the disclosure statement. It is also taken note of. This court also takes note of the submission of Mr. M. Sahewala, the learned counsel who represents the interim resolution professional, and submitted that the business transfer agreement only referred to those employees who were engaged by the petitioner in connection with the business, and the list of which was set out in Annexure B to the list to the business transfer agreement. He further submitted that in terms with clause 1.5, he further referred to clause 5.1.5, and submitted that for the purpose of effecting the transfer of the employees who were working with the petitioner to the respondent number 3, first of all, consent of each of the employees have to be taken. And the transfer would be effective from the transfer date, which is
30/12/2010.
30/12/2010. The Learned Council submitted that the award was passed on 28/1/2014. And as such, the directions so passed by the Learned Labour Court cannot be implemented for the respondent number 3. This court also finds it pertinent to take note of that the respondent number 4 and 5, who were the workmen, and the Learned Labour Court by the award dated 28/1/2014 had directed implementation, had directed their reinstatement with back wages. In view of the tussle between the petitioner, between the petitioner and the respondent number 3 are suffering, he submitted that he had filed an application before the Learned Labour Court in terms with section 33C(2)
Yes.
of the Industrial Disputes Act 1947 for ascertaining the amount which the respondent number 4 and 5 are entitled to. However, the said proceedings have been stayed. This court, having heard the Learned Counsels appearing on behalf of the petitioners, parties, have heard the Learned Counsels appearing on behalf of the parties, and have perused the materials from the court. It is the opinion of this court that pending the instant writ petition, it is a requirement for the interest of justice to pass certain directions, but to pass certain directions. This court have perused the business transfer agreement entered into by and between the petitioner and the respondent number 3. Though clause 5.1.5 categorically refers that the permanent employees of the transferor would be transferred to the permanent employees employed by the petitioner would be transferred to the respondent number 3 as on the transfer date that is 31/30/12/2010. But taking into account the dispute which was pending before the Learned Tribunal as to whether the termination of the respondent number 4 and 5 were justified by the petitioner, it has to be deemed that depending upon the outcome of the said proceedings, it has to were dismissed, whether the petitioner was justified in dismissing the respondent number 4 and 5. It is the opinion of this court that upon when the learned labor court by the impugned order award dated 28/1/2014 had held that the petitioner was not justified in dismissing the respondent number 4 and 5, they have to be deemed that they were always on appointment, even on the date on the transfer date. Taking into account that the dismissal of the respondent number 4 and 5 were on 6/3/2008, and the transfer date, the transfer date was on 30/10/12/2010, and the impugned and the award is dated 28/1/2014. This court further finds it very pertinent to take note of that in the proceedings so initiated by the petitioner before the learned labor court, only the petitioner have been arrayed as a party. The proceedings so initiated in terms with section 33C(2) of the Industrial Disputes Act 1947, the petitioner is only the party. It is the opinion of this court that ascertaining the entitlement of the petitioner would be in the interest of justice, and more so taking into account that there is an IPC proceeding in insolvency proceedings which is pending for the respondent number 3. Liberty given to the petition respondent number 4 and 5 to implead the respondent number 3 of the instant proceedings through the interim resolution profession, so that the learned labor court would be in a position to ascertain the liability. The question as to who would be making the payment would be subject to such orders to be passed by the would be liable to be payable shall be subject to next. Taking into account that taking into account the above observations, that the petitioner here, the respondent number 4 and 5 would be deemed to have been in the employment of the respondent number 3, as they were permanent employees of the petitioner, and the dismissal was set aside. Dismissal dated 6/3/2018. 8 was set aside by the impugned award dated 28/1/2014. This court directs the interim resolution professional so appointed by the National Company Law Tribunal, Mumbai, to take into consideration while preparation of the resolution plan the claims of the respondent number 4 and 5. Push. Next. This court further is aware of section 14 of the Insolvency and Bankruptcy Code 2016, which puts a moratorium in the proceedings in respect to any suit or proceedings. The above order, in the opinion of this court, is in aid to the insolvency proceedings which are pending with insolvency proceedings in respect to the respondent number 3. And as such, it is also the opinion of this court that the moratorium as mentioned in section 14 of the IBC 2016 would not be applicable. This court further vacates the order. This court further, in view of for the reasons assigned above, vacates the interim order dated 3/5/2023, past 5/2000, whereby the proceedings in case number 1/2022 and case number 2/2022 under section 33(c)(2) of the Industrial Disputes Act 1947 was stayed.
Lordship, can I add one more thing?
What?
Because if I go to impeach them following the due process of law, it will take time. I'll have to send a notice through post, registered post, then after that, service will complete, only then I can impeach, other than direct.
For that, I have already done it. Therefore, I have asked him to look into it. I know that. Because once you make them a party, the question will be different. There will be some delay. And there might be a stay to there also. Therefore, I've asked him. I also know that section 14 will get attracted with 33C. How much it is. So then they will decide that. What are these eyes?
17B. 17B.
17B, where is the 17B? That will be ascertained by that. What to do? Close it.
I may be closed because it has become non-functional.
Okay. Both IS filed by you.
Yes.
Okay. Taking into account the order passed in the petition, Mr. FZ Ahmed, learned counsel for the petition, who submits that he would not like to press the instant application, but would seek liberty to file a fresh one. So taking into account the above, the instant application stands closed with liberty given to the petitioner to approach this court by filing another application under section 17B, if so necessary at a later stage.
This matter may be taken at 2, my lord. Mr. Pathak is trying to connect to PC, my lord. Yesterday we have obtained the link also. And he has taken the file with him also, my lord.
The learned counsel appearing on behalf of a petitioner submits that he requires an accommodation. List the matter for 4 weeks.
Here, please.
Yes, Mr. Upaitya.
In this case, your lordship,
On 17/11/25, Advocate B.J. Talukdar took time for instructions. And after that, nothing has happened. Your Lordship.
I have the instruction, Lord.
You got the instruction. In this case, Your Lordship, we have applied for the conversion of our annual patta length into the periodic patta.
Mr. Upadhyay, kindly note down the citation.
Pardon, sir?
2017-13 SCC,
17,
2017-13 SCC 256.
2017,
13 SSC.
13 SSC,
256.
256.
And another citation with, Yes, this citation is relevant for your case yesterday. That case,
Earlier case.
yesterday you did a case,
Yes,
na,
yes.
before me,
Yes, yes,
that the national highway case.
yes.
So that will be relevant for you. Okay. So next time when it matter comes up before me, you use, I may forget. Yes, what is this case?
In this case, listeners have applied for converting their annual patta length into the periodic patta.
Hmm.
And they have filed the application before the circle officer.
Then,
Circle officer considered their case, and there is a final order of the circle officer. That is page 24.
page
24. And our proposal has been accepted, and fix the land value and fix the premium that we have to pay.
yes, then
Then nothing has happened, Your Lordship, because we have filed application before the district. District Commissioner.
why haven't you taken any decision?
Lordship, he has refused to pay the actual amount, Lordship. He has to pay 15% of the land market value. Premium has to pay 15% of the market value.
No.
He used to pay 10%, Lordship. That is my instruction,
No,
Lordship.
no.
Huh?
I am
According
ready
to
to pay
according
this
to the
amount.
notification, Lordship, he has to pay 15% of the market value. Premium, Lordship.
1.5.
1.5, Lordship.
Then
He wanted to pay 10%, Lordship.
pay 15%.
Yes, 15%, yes.
Lordship.
We close it
Yes,
by
yes.
observing that.
Lordship. Notification is also there. Notification is also there.
15% is, I am ready to pay.
So it is already fixed. You are saying it was 1,35,000. As I could see from that order sheet. Kindly
Yes.
see page 24. It is given at 1,35,000 only to the tune of 15% per biga.
Yes.
To
Tot-
Chalan,
Total amount.
yes. 1,35,000 you have to pay.
Yes.
You have refused to pay that.
Actually, there is misunderstanding, Your Lordship.
They say that is it.
We are ready to pay. We are ready to pay now.
heard Mr. N. Upadhyay, the learned counsel appearing on behalf of the petitioner. Mr. N. Goswami appears on behalf of the respondent numbers
3 and 4.
3 and 4. Mr. Arbor Pujari appears for respondent number 1 and 2. The petitioners herein are the legal heirs of late Kunti Hazarika, and presently possessing the plot of land admitting 1 bigha 4 katha covered by dag number 216 of annual patta number 17 of revenue village Jengni Katiof, Moza Nagor Mohol, district Sibsagar, Assam. The petitioner submitted an application on 29/7/2013 seeking conversion of the annual patta land to that of periodic patta. The record reveals that the circle officer of the Sibsagar Revenue Circle registered a case being Miadi case number 23/13-14. An order thereupon was passed, thereby opining that the petitioner had to deposit 15% per bigha the 15 of the value of the land, market value of the land, and observed that the petitioner has to deposit rupees 1,35,000. It is the case of the petitioner that it is the case of the petitioner that the fixing of 15% at the market value was too high and therefore sought for reduction of the premium by to 10%, that is rupees 90,000. The said aspect having not considered, the petitioner has approached this court by filing the present writ petition. Mr. N. Goswami, appearing on behalf of the respondents, have placed, respondent numbers 3 and 4 have placed an instruction issued by the Additional District Commissioner Sibsagar, which is kept on record and marked with the letter X, dated 20/12/2025, and is kept on record and marked with the letter X. Full stop. The parawise comments, which is enclosed to the said to the forwarding letter, and more particularly at paragraph number 3, it is mentioned that the petitioners were required to pay 1,35,000, that is 15% of the market value of the land, and the same was necessary in terms with the notification, then in terms with the circular issued by the Revenue and Disaster issued by the Revenue Reforms Department of the Government of Assam, dated 26/5/2005. It is also mentioned in the parawise comments that the petitioners, however, were not in agreement to pay the 15%. This could have heard the learned counsels appearing on behalf of the parties. Now tell me one thing. Today you are agreeing. That was in 2014.
No, 15 is
It has to be 15% of the market value as on today. Don't you think? Then
So I am ready to pay 1,35,000.
no, you cannot. You have, that was 1,35,000. After 10 years, you come Should I say it 1,35,000? Government is losing.
Current journal, hello. Current journal,
Ah,
hello,
you
that
have
is
to-
what my not the notification say, and if upon he is agreed, we have to challenge the notification.
This court have duly heard the learned counsels appearing on behalf of the parties and have perused the materials on record, including the circular dated 26/5/2005. 26/5. Pusto. The contents of the circular dated 26/5/2005 is of relevance, taking into account the petitioner's reluctance to deposit 15% of the premium as premium, 15% of the market value of the land as premium. Accordingly, the contents of the said circular dated 26/5/2025 is reproduced hereunder. From a perusal of the above quoted circular dated 26/5/2005, it is seen that non-alienated annual patta land converted within 10-kilometer radius of Gauhati and 3-kilometer radius of other towns shall bear premium at the rate of 25% and 15% of the market value of the land, respectively. As in the instant case, the land is beyond, is within 3 kilometers of other towns, the petitioner would therefore, in terms with the said circular, was bound to pay premium at the rate of 15% of the market value. Accordingly, the instant writ petition stands disposed of with the following observations and directions. The petitioner herein, the respondent number 3 and 4, and more particularly the respondent number 4, shall calculate the 15% of the market value of the land which the petitioner seeks to convert into a Miyadi patta land. And thereby inform the petitioner upon within 15 days from the date a certified copy of the instant order is served upon the respondent number 4. In the said order, next, this court further directs the respondent number 4 to also intimate the petitioner within a reasonable period to deposit the premium. This court further directs that in the circumstance the petitioner deposits the premium within that reasonable period, within the period so stipulated in the notice, in the information provided by the respondent number 4, the land of the petitioner, the annual patta land of the petitioner be converted into periodic patta, and appropriate and necessary corrections be carried out in the record of rights. You inform, your instruction is wrong. What they have said that we are still going to take 1,35,000. How can you take 1,35,000 now? 2014, what was the value of the land and what is today?
May I please look?
Yes, what is this?
My lord, in the year, my lord, 1983, my lord, 1 acre land was allotted in the name of my father, my lord. That is at page 21, my lord.
What happened?
Thereafter, my lord, my father died, my lord, and I am being the, my lord.
You were allotted some land.
No, my lord, I have not allotted, my lord. The land was allotted in the name of my father. Absolutely, by right of inheritance, I was possessing that land, my lord. And thereafter, my lord, I applied for, my lord, settlement. But without settling the land, my lord, without issuing any notice, I have been, my lord, house already demolished from and evicted me, my lord, from the said land, my lord.
Yes, Mr. Goswami, why you have done all this?
My lord, it was found after joint verification that
Huh?
it was found after joint verification, my lord, by the revenue and the forest authorities, that the land he was possessing, my lord, falls under the forest area, my lord. And there's a direction of this honorable court in a PIL, my lord, to evict all those encroachers. Accordingly, he has been evicted, my lord. He has no document to show, my lord, he had patta or allotment, nothing, my lord. And
But you had granted an allotment somewhere?
page 21 of the petition, he is claiming, my lord.
Page 23 is the original, my lord, certificate.
23.
Yes.
Yes, read it. No.
মানে নিম্ন তফসিল বর্ণিত মাটি আপনার ঘর
আজি ভোগ
আজি
দখল
ভোগ
কৰি
দখল
থাকিবলৈ
কৰি থাকিবলৈ তলত উল্লেখিত সত্য সাপেক্ষে আবণ্টন দিয়া হৈছে লগতে সেই মাটি বাসোপযোগী কৰি লবলৈ 750 টকা আর্থিক সাহায্য হিসাবে অনুদান দিয়া হয়েছে মানে now terms and
This was 83.
yes my lord.
You were
1983.
earlier allotted, not an allotment. This is not an allotment.
This is not an allotment, my lord.
This is a permission, not an allotment. See Rule 16 of the Assam Land and Revenue Regulation Settlement. You have it?
No, that's sorry.
Oh my goodness, you are appearing in this matter without that book. There must be two reasons. Either you must think that this court knows all the law, which is maybe incorrect. The other may be that you think that that is not necessary at all. Which one? The second one most probably. That is why you didn't get the back. This is actually, therefore I say, I asked you to read the language in Assamese. It's a permission being granted under Rule 16 that you are allowed to do it. But in fact, this permission is a precedent that once you granted allotment,
Yes.
till the settlement happens, you are allowed to permit. But where is the allotment?
My lord, thereafter, my lord, I have applied, my lord. That is, my lord, page 33, my lord. Page 33, my lord. And it's a 10.
33.
Yes, my lord.
Okay. Then,
My lord, thereafter, my lord, without any notice, my lord.
then what is this criminal case?
This criminal, my lord, case.
What is your name? Santosh Ali. You filed a criminal case against who?
Yes, my lord, against the, my lord, forest ranger and other, my lord.
Because they have evicted you.
Yes, my lord, they forcefully evicted. my
And
lord.
then,
My lord, I have submitted another representation before the district commissioner, my lord, deputy commissioner. And
now,
13.
Mr. Goswami,
My lord.
where is your finding that it is a forest land?
If my lord peruses my affidavit, my lord,
Where?
affidavit filed with the respondent number 5. Page 59 onwards it starts, my lord.
I think the Supreme Court, our division bench now has to relook these orders which have been passed in the PIL in view of the recent
Yes,
judgment. It's high time.
In fact, my
And
lord,
this judgment therefore should now be no longer there to be looked into. And more particularly when it is now the policy of the government that they are going to follow in view of the affidavit filed before the Supreme Court.
Yes.
Anyway, be that as it may. Now, where is the affidavit?
page 60, my lord, may kindly clear this.
It's 60.
60, my lord.
Yes.
Paragraph 3, my lord, the eviction was done. It is respectfully submitted that the eviction of the petitioner from the occupied
No,
land.
no. Where was the verification being carried out?
Paragraph 5, my lord. That pursuant to the Honorable Court's directive, a comprehensive survey of Nalbari Reserve Forest was conducted by the Range Officer Lakhimpur. During this survey, it was found that the petitioner was one of the encroachers in the said reserve forest, as listed in the encroachment.
Let's see the survey report.
If my lord peruses the survey report at page 76, my lord, petitioner is at serial number 7.
Survey report. Santosh Ali dwelling house is 2.5 bighas. What is that?
Yes, he claims 1 bigha. It was found to be 2.5 bigha. My lord.
Now let us see his allotment, which was.
My lord, land was, my lord, allotted, my lord, under tag number 157, my lord.
And
Now,
as
my
per
lord, in the year 2022, my lord, after verification, they said that this land fall under the forest land, my lord.
the instruction from the DC, my lord, though not filed in an affidavit, my lord. Huh?
This is Dag number 2.
My lord, not two, my lord, 200.
202.
202 is new, my lord. Earlier it was
202,
157. 202 is the new DAG. Earlier the DAG was 157.
157.
Then
If my lord peruses the affidavit filed by that's one number 3, my lord. It's the additional district commissioner. It is page number 42. It starts, my lord.
46.
42, my lord.
42 is by no, this is
Navadvip
Justice Service.
My lord, turns to next page, my lord, page 43.
Annexure 3.
Serial number, page 43, my lord, paragraph 4. That with regard to the statements made in paragraph 3 and 4 of the writ petition, the deponent begs to state that as per report submitted by the circle officer, Lakhipur Revenue Circle, Vice so-and-so, that is so-and-so, the land covered by DAG number 157 of Revenue Village so-and-so under Lakhimpur Revenue Circle, Lakhipur is recorded as government land. And during joint survey, joint verification along with the forest department, the land is found in question is found to be under reserve forest. What happens, my lord, usually once the reserve forest is notified, my lord, the revenue records are needed to be corrected, my lord. Usually, my lord, revenue authorities don't do that, my lord. So it's a clear land, my lord, clearly falls under this forest, my lord, Nalbari Reserve Forest.
When was this verification carried out?
My lord, it was.
Yes, DC.
Yes, my lord.
When was the verification carried out?
Report is of 8/11/2024.
Hmm?
Report of the circle officer is of 8/11/2024.
Where is that?
It's in the. It's not annexed by the DC, my lord, but a copy is with me, my lord.
And what is this Chita copy, Annexure 5?
My lord, Annexure 5 is, my lord, draft sheet. My
Yes,
lord,
yes.
we have
Paragraph
obtained, my
DC.
lord, photocopy, my lord.
You are the revenue. Come over. What is this Annexure 5?
Copy of circle.
This is DAG number 202.
202, my lord.
No,
And my name also, my lord, reflected, my lord.
Now, is this 202 and DAG number 157 is same?
same. Yes.
Is this a joint verification you carried out? Is this the joint verification you carried out as DC? Isn't it a high-handedness on your part? On one hand, in the Sita, You have put his name. Have you cancelled this shita? Wherein it showed that he is there. The fact that he is there in this particular document, which was a verification which was carried out, that he was there for the last 1980 is also not in dispute. 44 years a person is there in possession of that land. You just throw him like this.
Actually, we are not evicted, Lordship. Forest Department is evicted, Lordship.
You were very much present. That is what has been mentioned in the affidavit.
Maintain law and order situation, Lordship.
Law and order. What were you doing? As per Rule 12 of the Assam Land and Revenue Regulations, Assam regulations, you have no business in respect to forest land. On one hand, you issue SITA in respect to the very land, give it to them, and one fine morning, both of you internally carry out some joint verification without the notice or nothing is on record. Neither survey report, and you said, oh, there we made a mistake. 44 years this person has stayed, and therefore now it is forest land, we threw him out. Is this how you act? What happened to his application seeking allotment? That was allotment application was filed much prior to the year. What has happened to that?
But I have to take instruction, Lordship.
Huh?
That I have to take instruction, Lordship. But in our affidavit, Lordship, page 45, Lordship,
What?
in our affidavit, Lordship,
Whose affidavit?
ADC Lordship, page 45, para 7, Lordship, we mentioned that reported by the circular officer, October, April circle, the application not eligible as per guidelines of.
Why is it not eligible?
That-
Why? We informed him it is rejected. Very easy to draft out.
That instruction I have to
Huh?
take. That instruction I have to take.
It's a very serious infraction done by the district commissioner there. Which state? Gwalpara. Forest state of affairs. Is there any law and order under your district? No. Produce the map. What is the joint verification carried out? What are your reasons for rejection of his application? It is not eligible. Because he filed the application, you carried out the joint verification in the year 2024, as you say. His application is of the year 2021.
Yes.
If it is application is of the year, then did you know only in 2024? After the verification that it is not eligible. Doesn't the state of Assam have an act called the Assam Public Services Act? Right to the that is not applicable for them. Isn't there a mandate? Within what time you are to required to dispose of these applications? Or it only applies to whom you like? Something like that. Because in 2024, you have realized that it is not eligible because of the joint verification. He files his application in 2021. The fact that you have issued the allotment to him, not an allotment, a permission to settle, which is something, permission to reside, that is in terms with Rule 16, clearly shows that you had the authority then. Or is it something like that, which it is otherwise? Normally we find that the reserve forest, which area which is there, decreasing. Here is it increasing? Taking into account that at that point of time it was a revenue village. Or are you saying that those people have done it fraudulently? That we have been collecting taxes, revenue from them all this while. Revenue receipts enclosed. All this while. Illegally. In respect to forest land. Because the revenue has no business over the forest land. Return that money. You have taken the money illegally. We have no authority to take it. Lekho. Heard Mr. So-and-so, the learned counsel, appearing on behalf of the petitioner. Mr. P.N. Goswami, the learned petitioner advocate general, appears on behalf of the respondent numbers
Minor time, very
5. Mr. Arba Pujari appears on behalf of the respondent number 1 and 2. Mr. N. Goswami appears for the respondent number 3 and 4. The present petition has been filed by the petitioner seeking a constitutional tort, seeking compensation on account of constitutional tort committed by the statutory authorities, as well as also seeking direction that the petitioner, the respondent number 3 and 4, should allot a plot of land to the petitioner by the petitioner, taking into account that the petitioner admittedly have been residing over the land for the last 40 years. In that regard, the petitioner had also submitted a representation dated 8/2/2024. However, the same have not been considered. The record reveals that by an order dated 11/4/1983, the father of the petitioner was permitted to reside over a plot of land upon certain terms and conditions. The schedule to the plot of land, which had measured 1 bigha, the said plot of land had measured 1 bigha, covered by Dag number 157 core, village Hasdoba, circle Lokhipur, in the district of Gwalpara, Assam. It is further pertinent to take note of that from the order that the terms and conditions which were issued were that the petitioner's father had to construct a dwelling house. The petitioner's father thereupon constructed a dwelling house, and after the death of the petitioner, his father, the petitioner have been residing thereupon. It is also seen that from the Chita for the surveyed land, that is Dag number 202, which earlier was Dag number 157 core, as submitted by the petitioner. The name of the petitioner have been duly mentioned as being in possession. The petitioner submitted an application seeking allotment of the land, taking into account that his father as well as him have been residing for the last 40 years. And as such, filed an application seeking allotment on 12/11/2021 in terms with the Assam Land Policy 2019. An acknowledgement receipt was also issued to the petitioner. It is the case of the petitioner that one fine day, the respondent numbers 4 and 5, along with the respondent number 6, came to the petitioner's premises and demolished the dwelling house on
My lord, on
17/7/2023. Petitioner thereupon lodged an FIR. However, the said FIR was not accepted, for which the petitioner was compelled to file a complaint case before the court of the Chief Judicial Magistrate at Gwalpara, which was registered and numbered as complaint case number 350/2023, and the same is presently pending.
yes.
It is under such circumstances the petitioner had approached this court. Upon notice being issued, it is seen that the respondent number 5 had filed an affidavit in opposition. From the said affidavit in opposition, it is seen that a survey was conducted on the basis of certain directions passed by the learned division bench of this court in Sumoto PL number 1/2022. And it was found that upon the comprehensive survey of the Nalbari Reserve Forest (RF) Lakhipur range, that the petitioner was one of the encroachers of the reserve forest. The survey report was submitted on 1/7/2023, which have been enclosed as Annexure B to the said affidavit in opposition filed by the respondent number 5. This court also finds it very pertinent to take note of the affidavit in opposition filed by the respondent number 3 through the Additional District Commissioner, Gwalpara. It is surprising to take note of the contents of paragraph number 4 of the said affidavit. Taking into account that the petitioner was evicted on 17/7/2023, isn't it, Mr. Counsel?
Yes.
From a perusal of the said paragraph number 4, it is seen that the report was submitted by the circle officer on 8/11/2024, that is more than a year after the petitioner was evicted. Paragraph 4 of the said affidavit being relevant is reproduced hereunder. It therefore appears from a reading of the affidavit filed by the respondent number 3 as well as the respondent number 5 the survey which was carried out by the respondent number 5 was not in consultation with the revenue. Inasmuch as the survey was done, the report was submitted on 1/7/2023, whereas the respondent number 3, the circle officer, had conducted a survey, submitted the report on 8/11/2024. It is also interesting to take note of another paragraph of the affidavit filed by the respondent number 3. Wherein it is mentioned that as per the report of the circle officer Lokhipur Revenue Circle, the notice was issued by the Forest Department and eviction was carried out on 17/7/2023. But surprisingly, the reports so mentioned in the contents of the affidavit filed by the respondent number 3 are of the year 2024. This court also finds to take note of another aspect in the affidavit filed by the respondent number 3, wherein it is mentioned that the petitioner was not found eligible. Petitioner's application seeking allotment was not found eligible. But there is no reasons assigned. Fairness, transparency, fairness and transparency are mandates of Article 14 of the Constitution, which the state is required to observe. Merely stating that it is not eligible, that too on an affidavit, would not suffice when a person, as per the Assam Land Policy 2019, being in occupation of government wasteland, have a right to seek allotment. Being in occupation of government land, that too with permission. Under such circumstances, this court therefore fixes this matter again on 12th of March 2026. The respondent number 3 shall produce the joint verification report carried out between the circle officer Lokhipur Revenue Circle, carried out by the circle officer Lokhipur in association with the district forest officer Gwalpara.
Yes, divisional forest officer, my lord.
You have put district forest
My
officer.
lord, subsequently, my lord, cost title was amended, my lord.
Okay, divisional forest officer Gwalpara. In addition to that, reasons be placed before this court by way of an affidavit as to why the petitioner's application seeking allotment was rejected and when it was rejected. In addition to that, the respondent number 3 is directed to also in addition to that, both the respondent number 3, respondent number 3, 4, and 5 are directed to assign directed to place it on affidavit as to whether notices were issued prior to eviction of the petitioner, taking into account that the law laid down by the Supreme Court in the case of demolition, that is there. Citation? Justice Gauhati's judgment? Not this one. Because that was holding everybody. Everybody was holding that. So that.
That was in the context of other lands, not forest land.
No, for all lands. That is for every action. Demolition, that judgment is
I will give the number.
reported in so and so. List according.
That was the context of accusing criminal case.
Understood.
Demolition of property.
Understood. Accused in criminal case you were doing, that was the initial point.
Yes, that
But the
principle of
court
justice.
expanded the horizon and passed directions.
Yes.
And these directions, they were required to be followed. And therefore, now you have that Abdul Rasul, that what is that judgment out there which came before the Supreme Court, is also made on that formula which is being given. So therefore, that was the judgment which was holding. Otherwise, you would not have filed an additional affidavit before the Supreme Court and say that, look here, these are the things. Because if you have not done so, yes, you'll be entitled to a constitutional thought.
If I may submit for a moment, my lord, that judgment, my lord, has been distinguished by the division bench of this honorable court, saying that it is not applicable in case of forest.
Let it be done. You go against that order before the division bench.
Just a prejudice.
You see, then let the division bench look into that. For me,
Yes.
the judgment applies pan India for
True.
everything.
Basically, principles of residence.
A copy of the.
Let the division bench distinguish their judgment. That is their lookout. They have their duty. I have my duty.
Can I get a copy of this order? A copy of the order, sir.
Online. No.
You want a copy of the order? You can get it. Online, isn't it there?
Not.
Online? You can't get it online.
Get it.
Yeah. You want it? Okay. A copy. Mr. N. Goswami submits that he would a copy of the order be furnished to him. The registry shall provide a copy of this order for due compliance to Mr. Coenso and Mr. P. N. Goswami for due compliance.
Lordship. Premises, Lordship.
Possession of the building where?
Your
Who is in
lordship,
possession?
your lordship,
Who is in possession of the building?
they, your lordship.
They, your lordship, means the. office
They
of the joint-
categorically say out here that they are not in possession of the building. They have never taken the possession of the building with you.
Your lordship,
And
page
lordship-
number 5 of my petition.
Page 12 of that instruction, there are photographs as well, lordship. It was clicked yesterday, lordship. Now there is a go down kind of thing, lordship. Actually, she is the owner of two similarly situated building, lordship. She is the owner of two similarly situated buildings. Lordship, the adjacent building, lordship, that is in our possession and we are paying monthly rent. Lordship may come to page 13, lordship. Yes, the adjacent, that is additional chief medical and health officer's office,
So
lordship.
there you are getting the rent.
Yes, yes, there.
May I please, your lordship? May I please? On 7/10/2020, annexure 2, page number 22, they have clearly stated that they will take my building on rent with effect from 1/11/2020. And at that time only, I have submitted the room keys, house keys. Thereafter, is very true, there were two adjacent buildings. One is of my cousin, or I also don't know the name, but as per the instructions. But the other building is mine. My building was first proposed to be taken on rent by the office of the joint director. But later on, some other office has been stated by in the next building. Next building does not belong to me. I know the person since he's my neighbor, but it does not belong to me, your lordship. But my building was taken possession at that time, 2020, saying by this order dated, annexure 2, page number 22, your lordship. It clearly states, I have decided to take the building on rent with effect from 1/11/2020. They've decided, they promised me to make the agreement. Annexure 3 survey was done. Annexure 4, your lordship, fixation for house rent was done.
No, 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 no. Where is the handing over possession?
Lordship, I have categorically mentioned in page number 5 of my writ petition. Paragraph number 3, second paragraph.
Huh?
Page number 5, paragraph number 3.
No, 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 no. When the handing over the possession came. As of now, the building is still yet to be constructed. This is the photograph of the building inside. How did you go inside and take the photograph inside?
No, my lord, the entire stand of the petitioner is this, my lord, that it was till 2025, it was with the possession of the health department. Today, my lord, of course, he cannot prove it. But our instruction is.
No, no. How did you take the photographs at page 14? How do you take the photographs if you are not in possession?
No, my lord, they went to the building
How?
just to, my lord, show that, my lord, it's not under our position.
No, no,
And lord,
understand,
you will
but
see
how did you
The
enter?
adjacent building, my lord, it's presently it's in, under the health department. The office of the additional chief medical and health officer, FW, that office is there, but it's not of the petitioner.
No,
So
my
whatever
question-
is
no,
under us, we are just
Mr.
placing.
Gogoi, my question is,
Yes.
these photographs were taken on 24/2/2026.
Well, yes.
How did you enter inside if you are not in possession? My question is that you cannot intrude inside and take photographs inside. Can
Yes,
you?
going by, yes, my lord, that, but
Huh?
they somehow, my lord, they took this, my lord, probably, but it is not in possession. In fact, my lord, the petitioner's claim also, my lord.
You do one thing, you file an affidavit.
Right.
Pursuant to the order passed by this court on 22/2026, Mr. B. Gogoi, the learned standing counsel of the Health and Family Welfare Department, has produced a set of instructions wherein it is being mentioned that no possession of the building was ever taken, although the Joint Director of Health Service had proposed to take the building of the petitioner. It is also mentioned that presently the office of the Joint Director of Health Service is located at the constructed Doctor's Quarter at the District Civil Hospital, Jurapukuri, Hojai, since 16/12/2021. Taking into account the said stand, it is the opinion of this court that the said be brought on record by filing an affidavit so that the petitioner would be in a position to rebut to such statements. Accordingly, list this matter again on 9th of March, 9th of March 2026. In the meantime, the affidavit be filed on behalf of the Health Department on or before 6th of March 2026.
May I please, just a minute.
No. Next.
Deeply obliged.
Yes, anything you have done?
They say because of this public complaint and all, my lord, that note of the minister, my lord, is very difficult. But one thing I must say, my lord, they punished the instruction again, my lord, today. This is a transfer, my lord, which is within the, my lord, district. That's what they say, my lord, and temporary arrangement, my lord. In fact, my lord, in one order, passed by the division bench of the honorable court, the honorable court has held that, my lord, such type of arrangement, my lord, within the district, that cannot be termed as a transfer.
How does this apply?
Well,
How does this judgment apply?
same district, my lord, from one
Here
office.
it is same from one place to the station to another, but from one office to another at the same place of
Yeah,
station.
same place, man. Otherwise.
Is it in the same
Same
place?
district, yeah, in the same district, madam.
Here it is same station. See the judgment.
No, I have the sofa.
What does it say? Paragraph 9.
One station to another, madam.
One station in the same place.
On a or new place or
Normally,
It's
an
not from
employee
one-
is under is not under an obligation to demonstrate the justification for ordering transfer and interference by the court is circumscribed as it is difficult for the court to assess whether the transfer is in intent. The instant transfer order is not being challenged on the ground of malafide exercise of the power or on the ground of violation of the state, but on the limited ground of not recording justification which is prescribed to be complied when the transfer is made before completion of 3 years. The concerned memorandum do not specifically prescribe recording of justice or when the transfer is made from one office to another, but is made at the same place in name. Therefore, we are of the opinion that the records of recording justification specified in the office memorandum so and so would not apply to a case where the transfer is not from one place to a new place or not from one station to another.
well,
Accordingly, it is held that the judicial interference in such cases would not be justified.
and regarding the guideline part, my lord.
Hmm.
My lord, I would like to place this judgment. Says, my lord, even if there is a guideline, my lord, for transfer, that will not confer any right of to any employee to challenge the same, my lord, unless it is a backed by a statute.
You are therefore saying that these guidelines have no.
My lord, it can be,
No, we'll take it. We'll take it that it has no value. This is the submission.
my lord, supposingly now it has come to our knowledge, it can be regularized, my lord, with that particular consent from the MD. That's why I'm saying, my lord. And it is a temporary arrangement. It's not a direct transfer. They have clarified in the instruction that it's a temporary arrangement. It says
What is
temporarily.
this temporary arrangement? I don't understand. Means are you going to
Temporarily
bring him
transfer.
back?
My lord?
Are you going to bring him back? Is he earning his salary from where?
No, in that new, it will be in the new place. Of course,
Then how can
because,
it be temporary?
Another incumbent has joined in his place.
See, nowadays you have started a new set of new norms by which you are saying You are not going to transfer him from one to place. Don't use the transfer. We are just temporary arrangements. Why is he putting on a temporary arrangement because of public complaints?
And instead of going for some, my lord, inquiry, it can be done, my lord, to control the situation.
So
my lord,
therefore
to
you are
maintain the
saying that you are
environment,
doing it on a penal aspect.
my lord.
Penal.
In that also, my lord, the Govardhan Lal's case is very clear. Honorable Supreme Court has said that it can be done. Instead of going for inquiry, suspension and all, it can be transferred, my lord, to maintain the decorum, my lord, to maintain the situation, my lord.
So there must be something wrong with him.
So that's why, my lord, all those complaints, my lord,
Let us see the complaints.
complaints, my lord, it's already there in the bunch, my lord.
Yes. Let's read it. Page 30 of the complaint.
My lord.
This is written by, signed by some people.
I submitted a bunch, my lord.
10-10-2025. Ananya,
Yes, 10-10-25.
we'll read it.
আমাৰ বিনীত নিবেদন এই যে আমি নিম্ন স্বাক্ষৰকাৰী ব্যক্তিসকল বেলছৰ মহাত্মা গান্ধী সামূহিক স্বাস্থ্য কেন্দ্ৰৰ অঞ্চলৰ বাসিন্দা হওঁ আৰু যিকোনো সুবিধা অসুবিধা বেলছৰ AMG মডেল সামূহিক স্বাস্থ্য কেন্দ্ৰটোৰ লগত ওতঃপ্ৰোতভাৱে জড়িত আমি যোৱা 6 মাহ মানৰ পৰা লক্ষ্য কৰিছো ABDM হিচাপে কৰ্মৰত there's a petitioner স্বাস্থ্য সেৱাৰ লগতে তেওঁৰ ৰাইজৰ লগত ৰোগী অভিভাৱকৰ লগত তেওঁৰ সেৱা আৰু ব্যৱহাৰ পাতি অসন্তোষদায়ক আৰু সন্দেহজনক এই চিকিৎসালয়ত তেওঁ সেৱা দীৰ্ঘদিনীয়া হলে চিকিৎসালয়খনে বেয়া দিশলৈ গতি কৰিব গতিকে সময় থাকোতে তেখেতক ইয়াৰ পৰা বদলি কৰি অন্য ঠাইত নিযুক্তি দিয়াৰ ব্যৱস্থা কৰিবলৈ অনুৰোধ. So that was a prayer made.
So because of this type of prayers, you transfer. That's the norm. That's the norm.
No,
Because that is what has been held by that this order passed by the mission director.
no, not by the mission.
Additional
but by
mission
the joint
directors, this letter. We'll put it in these words that you do it. So therefore this can be done also. That merely on the basis of lighting also a person can be transferred.
If the publics are complaining,
So if the public is complaining, therefore you act.
yes, sir. That is the reason of the transfer, my lord. On the record, this is the ground, my lord.
Okay, madam. Anything you have to say?
No, your lordship, but still that query hasn't been answered, your lordship, which your lordship had placed. That whether there was a violation of the order. We are only because of that, your lordship.
But they say that it is not necessary. Where's the judgment? They say that it is that has no value.
No, that instruction also I have placed, my lord. It's there in the court record.
No.
That
On that
instruction-
aspect pertaining to the guidelines issued by the directions so issued by the Director of Health Service.
Yes.
You say that has no value.
No, I'm not saying that, my lord, but that cannot be a illegality, my lord. That's what I want to point out, my lord.
So that means that order can be not be considered. Heard Ms. M.K. Brown, the learned counsel appearing on behalf of the petitioner. Mr. B. Gogoi, the learned additional AG appears on behalf of the respondent numbers 1, 2, 3. Mr. So-and-so appears for the respondent number 4. The present writ petition has been filed challenging the transfer order dated 14/11/2025, whereby the petitioner was transferred from BPHC Samota to BPHC Mukalmua, whereas the respondent number 4 was transferred from BPHC Mukalmua to BPHC Samota. Pusto. the case of the petitioner herein is that the said transfers were made is contrary to the order passed by the mission director dated 30/8/2022, wherein it was categorically mentioned that the employees of National Health Mission Assam at district and sub-districts should not be transferred or attached, bracket including allowed to work by the Joint Director of Health Service or any subordinate office at the district or the sub-district level. The learned counsel appearing on behalf of the petitioner submitted that taking into account that the mission director of the National Health Mission Assam is the highest authority in respect to the said highest authority in the state, the Joint Director of Health Service could not have exercised such jurisdiction to transfer the petitioner by the impugned order dated 14/11/2025. The learned counsel appearing on behalf of the petitioner further submitted that the petitioner has 8 months of his service left, but the respondent authorities, the respondent number 3, not only disregarded the order, the standing order of the Mission Director, National Health Mission, dated 30/8/2022, but also did not take into consideration that the petitioner had just 8 months of service left. The learned counsel further submitted that not only that, the respondents have also not taken into consideration that the petitioner had various ailments, and as such, at this fag end of his service career, he could have been retained in the said office till his retirement. This court, pursuant to the filing of the instant writ petition, did not issue notice. No interim order was passed, taking into account that the writ petition was filed almost 2 months, 2 months pursuant to the order of the transfer dated 14/11/2025. Be that as it may, this court inquired with the learned counsels appearing on behalf of the respondents as to whether the order so passed was contrary to the order, the impugned order so passed was contrary to the order dated 30/8/2022 passed by the Mission Director, National Health Mission. When the matter was taken up on 2/2/2026, a set of instructions were placed before this court, assigning the reasons why the petitioner was transferred. The first reason so assigned is that there was a direction issued by the minister, Chandra Mohan Patwari, to transfer the petitioner, as the same is apparent from the office note dated 14/11/2025. The second reason is there is a complaint being made on 10/10/2025. However, nothing has been placed before this court that based upon such complaint, there was a satisfaction of the authorities concerned that the complaint so submitted on 10/10/2025 was had any substance. Full. This court further takes note of that in the meantime, as there was no stay order being granted, no stay order was passed. The respondent number 4 had in the meantime joined his place of posting, taking unilateral charge at BPC Samota, taking unilateral charge. This court further heard the matter on 16/2/2026 and taking into account that the petitioner had submitted a representation which was not considered, which remained unredressed, an opportunity was given to the respondent authorities to decide on the said representation. Today, when the matter is being taken up, Mr. B. Gogoi has placed a set of instructions in connection with the representation submitted by the petitioner.
Para 6 is the final order. Final decision is para 6. They've given the para 6 of the instruction.
This is what you.
Yes, this instruction.
The said instruction is kept on record and marked with the letter Z. From a perusal of the said document, which is kept on record and marked with the letter Z, it is mentioned that there was a public complaint duly signed by local residents under the jurisdiction of MG Model Hospital, Belsor, relating to the petitioner's performance in public service and alleged disharmonious conduct. It was further mentioned that though the petitioner had cited physical weakness and health-related issues, but in the greater interest of public service delivery, the concerned district health society effected his temporary transfer. It is also mentioned that the action of temporary transfer of the petitioner along with necessary replacement has already taken was necessary and justified. And any further stay of transfer of the petitioner may lead to agitation amongst the public. This court, having perused the document which is kept on record and marked with the letter X, do not find that there was any subjective satisfaction on the part of the concerned respondent authorities as regards that the allegations so contained in the public the allegations so contained in the public complaint had any substance. On the other hand, from the document which is kept on record and marked with the letter X and the enclosure therein, which is an office note dated 14/11/2025, it is seen that the transfer of the petitioner was effected as per the direction received from the minister, concerned minister, namely one Chandra Mohan Patwari. This court have heard the learned counsel appearing on behalf of the health department. Who submitted on the query being made in for the order dated in respect to the order dated 30/8/2022, which was issued by the Mission Director, National Health Mission, that there cannot be a transfer or attachment of an employee under the NHM to be issued by the Joint Director of Health Service. He submitted that the said order would not confer any right upon the petitioner. In that regard, he has referred to the judgment of the Supreme Court in the case of State of UP versus Govardhan Lal, reported in 2004, 11 SCC 402. Wherein the Supreme Court observed that unless the order of the transfer is shown to be an outcome of a mala fide exercise of power or violative of any statutory provision or passed by an authority not competent to do so, an order of transfer cannot lightly be interfered as a matter of course or routine for any or every type of grievance sought to be made. But a question arises in those facts, but the question arises in the present proceedings as to whether the Joint Director of Health Service had the authority in view of the existence of the order dated 30/8/2022, passed by the Mission Director, National Health Mission, who is the head in the state of Assam in respect to the National Health Mission. It is pertinent to take note of that the order dated 30/8/2022 categorically mentions that the Joint Director of Health Service or any subordinate officer at the district or the sub-district cannot transfer any employee under the NHM. Therefore, the very competence of the Joint Director of Health Service is the question which is before this court. The judgment in the case of the Supreme Court, in the case of Govardhan Lal, makes it very clear that in the circumstance when a transfer order is vitiated by mala fide or is violative of the statutory provisions of law or passed by an authority not competent to do so, can be interfered by this court under Article 2 to 6 of the Constitution. The order dated 38/2022 is an order by which the power of the Joint Director of Health Service have been taken away to transfer within the district. Under such circumstances, it is therefore the opinion of this court that the interim transfer order dated 14/11/2026 was passed by an authority having no competence. Accordingly, the instant petition therefore stands disposed of with the following observations and directions. The interim transfer order dated so and so is set aside and quashed. Number 2, the stands aside and quashed, comma, the petitioner herein shall be permitted, shall join his office at BPC Somota within 5 days from today. Within 3 days? 3 days from today. And taking into account that the order of transfer was issued by an authority not competent to do so, comma, the period during which the petitioner have not been able to, the period from the date of the petitioner's transfer order till the petitioner joins within the time permitted herein above shall be construed that the petitioner have been functioning as in the BPC Somota. This court also duly takes note of that the respondent number 4 had in the meantime joined pursuant to the transfer order dated 14/11/2025. As the transfer order dated 14/11/2025 is set aside and quashed, the respondent number 4 shall therefore be deemed to be in service at BPC Mukalmua during this period.
With the lordship. This is the case where the BTC passed an order over the order of a settlement officer, lordship. Thereafter, your lordship has.
Not
raised-
today. I am fixing a date. This is not a matter. This matter will take some time.
Lordship.
I know the matter, but the sad thing is, after I left this matter long time back, when was it? Last time I finished the matter in 2024. Nothing has happened thereafter.
Can I just point out, my lord, coincidentally, I happen to be there in the other case. The notification under challenge, my lord, which confers power on the secretary of BTC to exercise the power of appeal, is also under challenge before the division bench in WPC number 5678 of 2024.
Regarding?
Same question.
Regarding what challenge?
There, the notification dated,
Uh.
I think 30, 1 second. 30/12/16 is under challenge. My lord, but I have checked up, my lord, subject to what your lordships may say. It appears, my lord, the exercise of power is not bad, my lord, because there are provisions in the 6th schedule, my lord.
Regarding?
Yes, my lord. Well, actually, my lord, it has this memorandum by which this power has been given on the particular officer. It has to be construed as a, my lord, executive exercise of power, which is again permitted. In the meantime, my lord, state has also framed a law. It has been sent to governor.
What was the
Where
matter?
they want to confer
Let me read that order.
Yes.
This court by an order raised the question regards the authority of the BTC to decide an appeal against an order of the settlement officer in view of the provision of section Iman. This court further inquired with the learned counsel appearing on behalf of BTC as to whether the notification dated so and so can override the provisions of so and so. And upon finding the matter on so and so on the same date, an instruction was placed before this court issued by the Joint Director of Joint Secretary of VIA, wherein it is stated that the BTC had not intervened with authorities to whom the appeal lies under Section 1. It was also stated that the appellate authority should be the Assam Board of Revenue as per Section 146. However, it is also stated that by the notification, the BTC being a tribal area and autonomous council and its administration is run by the sixth schedule of the area, the BTC authority ought to be the appellate authority, the first in the BTC area. It was also mentioned that the decision passed by the Secretary of the Department, if agreed, may appeal before the Assam Board of Revenue. In view of the said instructions to produce this court inquired with the learned counsel appearing on behalf of as to whether the same would not amount to amending Section 1. Software instruction. Today, when the matter has been taken as so and so, the will submitted to the learned, the has been entrusted by the PTC. On the other hand, this court also taking note of the issue involved in it, taking into account that the learned counsel appearing on the hand has insisted the interim orders so passed by this court be vacated. It is seen the Eastern Settlement Officer had granted invitation to the petitioner hearing in respect to the plot of land measuring. This order was challenged before the Assistant Settlement Officer by the Swans.
8, 6, 7, 8. The division.
You have a status quo order in your favor. So why are you in a hurry?
Lordship, it's pending since long, Lordship.
Oh, you have it.
No, I think matter requires some time, it will require some time, Miller. It's an important point.
Lordship, already BTC has filed their affidavit in the writ petition before the division bench, Lordship.
Why the division bench taking up a notification matter? The division bench nowadays have no matters. Yes.
I think
Oh,
under the
writ
High Court
appeals
rules,
nowadays-
no, I don't know, Miller. I'm a
Are
respondent
the,
there.
are the single judges so competent that the councils are not filing writ appeals? What is the problem
No,
with
it's
the
not
division
an
bench?
appeal, Miller. It's a writ petition.
It's a writ petition.
That's
Somebody
why-
challenged
that is
the
why, no.
validity of that
If
notification.
there are too many writ appeals, obviously no writ petitions would be entertained. Challenging a notification, because notifications are challenged before the High Court, before the single judge.
It can be
It is
done.
not, it is the norm. It is only when a rule is been challenged, or
Statutory
an
rules.
act has been challenged, then only. And that to a statutory rule. Then only the division bench takes it. But anyway, I think the division bench has dirt of matters.
If your lordship, give me just 1 minute, recommend, just with regard to this matter, whether the BTC has the power to issue executive orders or not. My lord, as per the constitutional amendment, my lord, 10/2/2003, there is a memorandum of settlement. That memorandum of settlement find place in the constitutional amendment itself under paragraph 20 of the sixth schedule of the constitution. 10/2/2000, that's been recognized, and that's a part of the constitution. That memorandum of settlement, my lord, empowers and gives executive powers to the BTC itself, my lord. And that's by way of the constitution itself. All the subjects, 40 subjects, land and revenue has not been entrusted to us till now by the Assam government, but all other subjects have been entrusted by way of another government of Assam's, my lord, office memorandum, wherein executive
Most
powers
of
is
here, I
vested in
understand that. The question are twofold. Most pertinent is the Assam Land and Revenue Regulation applicable to BTC?
Well,
you take a stand that you have your own right.
Yes.
You have to. So is the Assam Board of Revenue, is the Assam Land and Revenue Regulation, Assam Board of Revenue Act are being applied for insofar as the land of the BTC is concerned? That is one issue. If you say, because the thing which was happening before the court is different, they say land and revenue regulation is applicable. If land and revenue regulation is applicable, 147 is applicable. So can you amend 147 then? There the question is.
And for that purpose, they included an office memorandum with regard to the in 2010 itself. That laws, rules regarding Assam government, my lord, we adopted with modification. By of executive.
So there
process,
has
that
to be
been
a-
Modified. That power has been given to BTC, my lord, second.
So therefore, there has to be a modification being carried out to that effect. That we adopt this Assam Land and Revenue Regulation, but 147 is amended insofar as applicable to us to that extent. Where is that?
That's true.
In
That
fact,
is not there.
in fact, my lord, in the affidavit filed by BTC before the division bench, my lord, this is the stand they have taken. It is also pertinent to mention that BTC has forwarded the bill, Boroland Territorial Council Land and Revenue Regulation, Application and Amendment Bill 2024 to the Commissioner and Secretary to the Governor of Assam by this Secretary as memo dated so and so. It is further stated that until and unless His Excellency the Governor of Assam assents to the bill will have no effect, and therefore BTC cannot exercise its absolute power on land matters, which is an entrusted subject to the council authority. This
That
is the
problem.
stand.
Therefore, that is why you have this problem.
That is going on.
Well, therefore, if the Assam Land and Revenue application does not apply, that's a different thing. But if that be so, then
I
how
mean,
do I
once
having the
this
settlement?
amendment is through, my lord,
No,
perhaps it will take care of
that is a different thing. But this has to be prospective.
Yes.
It cannot be.
I was only looking from a slightly different perspective. Right?
Yes.
I was only thinking since land revenue is a transferred subject, therefore legislative power is there with the BTC.
Absolutely.
Now issue is whether BTC also has an executive power. That in my humble submission, my lord, subject to what your lordships may say, it appears there is.
Yes.
Because, my lord, the memorandum of settlement of 2003 has been construed to be an legal document within the meaning of.
Mr. Chaudhary, kindly
Where-
appreciate
where there is a
appreciate
provision-
another very important thing. Then, where do you get the settlement officer?
No, that's a different thing. my
No,
lord.
no.
How
Where is the
administer-
settlement? How does the assistant settlement officer work
Right.
in
No,
BTC?
that is there, my lord.
Everything is to be there.
My lord, 5
So unless that act does not come into,
yes.
so the entire thing which you have done is
No,
wrong.
no, my lord.
Whatever
No,
is
subject to
required-
correction, ek minute. My lord, 5.1 of the memorandum of settlement says, council shall have legislative power in respect to subjects transferred to it as enumerated at Annexure 3. That means MOS. All laws made under this paragraph shall be submitted forthwith to the governor and until assented by him shall have no effect. That is important. BTC shall have executive, administrative and financial power in respect of subjects transferred to it.
So it is
can be
similar to
construed as
161.
equivalent to 162.
162. So
Yes.
this is the 162.
Yes.
This power is there.
Ah.
But therefore, the question is,
Yes.
if you don't apply Assam Land and Revenue Regulation, where is the question of settlement or anything?
No, I don't think BTC disputes that. Only question.
No,
that
no, no. The moment you are filing an application before the governor asking for the year, unless there is an executive instruction
Ah.
that till this is not being done, we are going to follow this, then the entire exercise being carried out as
Possibly,
regards
they will have
settlement,
to-
everything will go for a knot.
Possibly they.
Everything is required, my lord, with regard to land and revelation, we adopt it with this modification and that is to be placed before the executive council ratifies it and then we can do it.
So therefore, prior to that, have you issued any notification to that effect?
Yes,
Under
no,
one,
There is 2010 notification.
yes, no, no,
my lord.
no, no. 30/12/2016 notification.
Yes, there is.
That is the notification.
what is that? Let us see
Yes.
that notification. sir.
If his lordship is holding the WPC 6069, in that case, my lord,
Affidavit in
affidavit filed by the BTC, my lord, last page, page 47.
Page?
Page 47, Milord, 30th of December 2016. Affidavit filed by BTC 3, 4, and 6.
Whereas clause
Whereas
5
as
of
per
MOS
clause
so
so
and
and
so,
so
the
of
office
MOS so and
kept
so,
outside the
the office of deputy
control of
commissioner and superintendent are kept outside the superintendence and control of BTC,
the council.
and land revenue is a transferred subject of BTC. Therefore, the council head of the department directorate formed by BTC with regard to land and revenue department write notification details so and so and so and so and so and so. They respectively shall be competent to deal with all land and revenue matters of 4 districts and
So
power of the
therefore,
deputy
no, but problem arises is, where is the adoption?
Huh.
Without an adoption, you are having an appellate authority.
Adoption is 2010. It's been there is a notification. It's not been mentioned out there. But
I think
adoption
what
there
we'll
is-
do, Lord, we'll compile all the notifications and all, then Lordship will have the matter. Perhaps that will be
Because
better.
unless you have the adoption,
Right, right.
the question of land and revenue applicability is not there.
That is there in 2010.
Joining Tikatha.
And prior to it, it was a BTC. Then what was the law? Because the BTC only became in 2003.
Something like Article 372, pre-existing law, whether it will be adopted, if it is adopted. with
What will happen then?
modification.
There is another thing. New law not coming is a different thing. But old law coming,
Pre-existing law.
if old law comes, then you have to amend.
Amend or adopt it with whatever modification or as it is.
Then do you need to adopt?
Yes.
The question
Correct,
is,
correct.
you may not need to adopt. If it's a new law, you may have, but which is the law which is existing. But you see, in Arunachal Pradesh, Arunachal is a fifth schedule, not a sixth schedule.
Not 6.
It's a sixth schedule. So Arunachal
And
is
my lord,
different.
there are quite a few aspects which needs to be addressed.
Okay,
Lordship
okay.
will have a date, my lord. We'll
When?
try to assist your lordship. There's no hurry, my lord.
You are enjoying a stay. Status quo is there?
Status quo is there,
There?
Lordship. Till disposal of the petition, Lordship,
Oh,
until
there?
further orders.
I think we should have it after 2 years.
No, after April, in the April,
Lordship,
after
as in the
the,
meantime, they have stated that they are going to enact a new law, Lordship. So the, which was done,
So if you make a new law, how does it matter?
Lordship,
It
So the
has to be given retrospective operation.
Lordship.
See later on whether the law is there or whether Assam Land and Revenue Regulation automatically applies because they only came in 2003. That land in that area already the Assam Land and Revenue Regulation was applying.
no, April. My lord, 23rd April, my lord.
Because you see, Assam Land and Revenue Regulation says in certain areas it was not applicable then also.
And Assam Land and Regulation is a central act, because at that point of time, it was governor in council.
Council. And no, not only that, the Assam Land and Revenue Regulation at that point of time also excluded certain areas.
Yes, yes.
Just, just for example, the Hodia tract.
Yes.
That was
Correct.
excluded. Tirap tract was excluded. Then if you come down certain areas, Nagaland, this was excluded. These were excluded at that point of time, although
Correct,
they
correct.
formed a part of the state of Assam.
In fact, my lord, they were much more conscious of the rights of the different sections of people.
At that
British
point of
were
time.
much more conscious. If it is not inconvenient, my lord, could it be in 23rd of April, my lord?
27th to 20. 28th, my lord, if your lordship.
28th of May, my lord.
28th.
Sorry, April.
28th April, yes, it's
Yes.
free.
Lordship can be as a part-heard matter, Lordship.
What part?
हो जाओ मैं
What part?
At 2 PM, Lordship.
No part, no part.
No, let it be
Lordship-
part of me, Lord.
Part-heard,
Interesting
Lordship
part.
has, Lordship has.
This matter.
और लॉजिक में give us a father hearing.
For father.
Father hearing में
Has been, this court have heard the learned counsels for both the learned counsels appearing on behalf of the parties at length on the issue involved. taking into account that the instant repetition would take some more time and certain more and certain would require further would require further more in-depth analysis. This court fixes the matter on 28th of April 2026 for further hearing.
Milord, can I make an unusual request? Milord? There's one item, Milord. They have some, I should go early, Milord. On Monday, I'll do it. Item number 13, Milord. Monday, I'll do it. Yeah, I'll inform the other side. Deep, Milord.
Yes, affidavit not filed.
Your Lordship, I have received my instructions. So my instructions are that his shop, there is a.
I want to shift my shop, only.
Yes, so otherwise he has to confirm with the requirements of Rule 289. Read 294A.
94, my lord.
294A and 289. He has to. So let him file a formal application that the Deputy Commissioner consider it in terms of the rules, and then perhaps if he's agreed.
294.
294A and 289.
289 and 294.
294A.
And 289.
So we close this with
Yes,
liberty
because-
given to you to file here and if aggrieved, come back before this court. The petitioner herein is aggrieved, heard Mr. P.K. Roy Chaudhary and Mr. K.P. Pathak appearing on behalf for the petitioner and K.P. Pathak appearing on behalf of the Excise Department. The petitioner herein is aggrieved by the decision of the government to close down the IMFL shops situated within 500 meters from the outer edge of the national/state highway in the Gaon Panchayat area, and therefore has sought for various directions. Full stop. Mr. K.P. Pathak, the learned counsel, appearing on behalf of the respondents, submits that the petitioner to be eligible for an IMFL on or off license has to comply with Rule 294A and 289.
289 to 292 is the compliance. 294 is the process of shifting of a license.
With comply with what?
He has to comply with the requirements under 289 to 292.
289 to 292
Yes.
of the Assam Excise Rules 2020.
2016. 16.
And if the petitioner submits an application as per the procedure mandated in 294A, the respondent authorities, after due compliance, the respondent authority shall duly consider the same. Taking into account the same submission, Mr. P.K. Roy Chaudhary submits that the petitioner would be well advised to, if the petitioner would not like to further proceed with the instant writ petition, rather the petitioner would file an application before the concerned authorities as per the provisions of law. He, however, submits that in the circumstance such application is rejected, the petitioner be given the liberty to approach this court. Taking into account the above, the instant writ petition therefore stands closed on withdrawal. So the petitioner would be at liberty to file appropriate application seeking IMFL on or off of license.
License was there.
Shifting of license.
Shifting of shop.
It would be at liberty to file appropriate application seeking the shifting of the IMFL off license to by complying with the mandate of section 289 to 292 of the Assam Excise Rules 2000 year. It is further observed that in the circumstance the petitioner is aggrieved by such by rejection, the petitioner would be at liberty to approach this court. Mr. Das, what is this?
My lord,
Why no affidavit filed?
Page 32, my lord. The Deputy Commissioner wrote to the Additional Chief Secretary.
Huh?
Sir, my lord,
What is your relief?
Sub-Divisional Land Advisory Committee already, my lord, named my lord, already, my lord, defined the also the premium also, my lord.
So land has been settled.
Yes, my lord, but this, my lord, in spite of that, the secretary to the government of Assam has not issued.
What is this, Mr. Yeah, Mr. Borpugari?
As the LIC has, we have made communication pursuant to order passed by the Honorable Court and are checking the instructions from the department. Now the department in turn, my lord, had requested the district commissioner, and the district commissioner has given up some, my lord, paragraphs common instruction where, my lord, the same fact is repeated. So I need to take specific instruction with regard to page 32, my lord.
Mr. R. Borpugari, appearing on behalf of the petition respondent, Revenue Department, submits that the petitioner, that the instruction so placed before him, so provided, is not relevant, and he therefore requires specific instructions in respect to Annexure 10 to the writ petition.
Yes, my lord, that is, my lord, communication dated 28th of October 2016.
That is it. Taking into account the above, taking into account that the present proceedings, that the grievance of the petitioner stands unredressed for the last 1 decade, a final opportunity is given to the respondents to bring on record their stand by filing their affidavits on or before 6th of April 2026. Liberty given to the petitioner to you file by 8th of April 2026. Let me spoil Mr. H. Das Bihu and ask him to file his reply by 28th of April 2026. List the matter on 24th of April 2026. You also file your affidavit.
Lordship, may I just place a judgment of this honorable court? The society, the petition number 1's registration under the Society's Registration Act expired in 2015, right? 2015.
Review has been filed now. The mention was.
We have not given a copy.
Notice issued. I have not filed it.
You have not filed it.
This condonation is not required. It's a 227 application. Review condonation. We said that the application is not.
My lord, the review petition, I have not filed the review petition because, my lord, in the review petition, Gymkhana Club is a party. Mr.
Who has filed?
Mohanta has filed. Who was here?
Who has filed review?
Since, my lord, the Gymkhana Club is a respondent in the review petition, my lord.
Who is Brahma Kumar Mohanto?
My lord. He is one of the, my lord, members who filed the, my lord, earlier one IA. In those, my lord, number of cases which your lordship has disposed of saying it to be, my lord, infructuous, redundant. So there, my lord, the review petition has been filed. And since, my lord, in that IA, the Gymkhana Club was a party respondent. It's your case. It is your case. No, I will be taken. I is taken.
That was a civil matter.
So you are not a party earlier.
Well, may I make a disclosure first, my lord? In this matter, my lord, I'm representing my father, my lord. I've checked the rules, my lord. There's no impediment. I'm just informing this court, my lord.
You are representing?
My father, my lord. The review petitioner is my father.
Then?
I'm just disclosing it, my lord.
So isn't it one of the code of conduct that you cannot represent your father?
I checked up with the code of
Such code of conduct. There's no such code of conduct.
I checked up with the.
He can represent his father.
Can he?
I checked up the code of conduct, my lord. If there's any impediment, I would, my lord,
Is there
recuse
an
out.
interest?
No, there's a bar in the rules. Advocate Secretary, CRP, Law Council.
Here,
Here it is not a party.
but here he's not the party, he's
The writ petition is not a party.
he is a different person altogether. Different person altogether, that's what it seems. I don't know. We don't have a copy of the review, so we really wouldn't know.
The review copy has not been served. It's been filed to them. I'll hand over the copy. The notice is not issued.
You are representing us.
I think unlisted.
Unlisted.
Yes, I mentioned it in the morning.
That is no. The genuine part. This, you children that was there in this.
No, this was.
He's a stranger to the proceeding.
Yes, you read petition, but earlier, the institution, it's where the mistake. That I, that also was.
Come to this, duty to the court. An advocate shall not enter appearance, act, plead, or practice in any way before a court tribunal mentioned in section if the sole member of any member thereof is related to the advocate as father, grandfather, son, grandson, uncle, brother, nephew, first cousin, husband, wife, mother, daughter, sister, aunt.
I was not-
Anything more?
That's why I made the disclosure, Milad. I'll.
Because I had seen these rules very properly while we were making the senior advocate rules. So at that point of time, we were looking into these. These are the code of ethics rules made by the Bar Council. Standard Professional Code of Ethic, Conduct and Etiquette, which is at chapter 2 of the Bar Council. So
He's representing his father. I'm a little confused actually. What is it?
he's appearing for his father. So he cannot appear.
Yes.
It's okay. You engage somebody else.
I'll engage.
We'll have it on some other day.
My
Because
apologies,
it
Milad, I
would
was
not be
aware.
proper because if you
Yes, yes.
appear tomorrow, it will have an.
Exactly.
That is
that's
why the rules are there.
That's why I made the disclosure, Milad.
That's okay. You are he? Junior?
He's with me.
Junior. Mr. So-and-so. Submits that they taking into account the it is the opinion that the instant matter is not a matter which can be taken up as an unlisted by way of a production list. List the matter on 27, 28, on 2nd of March 2026. In the meantime, you engage somebody, huh?
And the other one, item number 9,
What is that?
this is, that's a writ petition where
9 will also go. List this matter on 9. Second.
Let him have copies on all the minor parties. Copy may be served upon both of us.
Obliged.
Obliged.
They will maybe taken up with yesterday matter lordship that Enoch will file affidavit fixed on 9/3.
Here also same.
Same lordship.
And in extra representation has not been submitted, lordship. Only one representation submitted, lordship. One representation page number 54, lordship. The one representation with register post, lordship.
Here he has filed a representation in the year 2025.
Lordship.
You were sleeping all the while.
Whatever, lordship, so.
I think we should dismiss it on that ground only.
Lordship, Supreme Court
You were sleeping all the while. What on earth were you doing all this while from 2025?
Similar serious person already entitled, lordship.
So what? That person came earlier.
So, lordship, they physically approached before the concern.
No, that person came earlier. That person came in
So,
2021.
lordship, we do respect, lordship. I may be wrong, lordship. Two Supreme
You are a
Court-
fence sitter.
Lordship, honorable.
Fence sitter.
Lordship,
Okay, list this matter along with
Lordship, 6259 of 25
on
9/3. 9/3.
Massachusetts.
you take the point of fence sitter.
Lordship.
Yes.
Same lordship.
May it please your lordship, my lord. My lord, here, my lord, I am the auction procedure matter. If plot of land was sold in auction, my lord, my sale certificate lordship will find.
Affidavit file.
My lord, affidavit file, recently also filed, my lord.
Then what is there? What is the, your land has been taken?
My lord, they are not giving now the possession of the land, my lord, page 23. My lord, this is the land, my lord, this is sale certificate.
Who appears for the respondent?
My lord, M. Sharma, he filed the affidavit. He was there, I saw him, my lord.
Lordship, his legs in another court, Lordship.
Okay,
May I
this is
kindly
the
please-
matter. Taking into account the counsel appearing on behalf of the Central Bank of India is not present. List this matter on
Next week, my lord.
11th of March 2026.
Much of.
Lordship, in this matter, Mr. Kane Chodri had made this mention. Mr. Kane Chodri has made this mention.
Oh,
that
13.
On Monday, it may be taken.
No Monday. Why? What is the urgency?
Lordship, we are the petitioning society and we are not being able to operate the account and the
What
bank,
account?
the bank account.
Why?
Lordship, what has happened is that
Well, there is a disputed facts between the two group to operation of the school, my lord. The management of the school now fighting between the two groups, my lord.
Then why? Suits are being filed.
yes, and we had an interim order. We had filed an injunction petition and we had got.
Well, I will request, and we'll have it on 13th March. The request of Mr. K. N. Chaudhary, the learned senior counsel, matters will be adjourned to 13th March. Vashal Singh. Yes, what is this?
Lordship, in this case, we have challenged the illegal actions on the part of the respondent forest authorities in Lordship, seizing my vehicles which were outside the jurisdiction in Arunachal Pradesh. They went from the Assam to Arunachal Pradesh, and one is, they entered the house while I was in custody. Lordship, if your Lordship looks into the sequence of events, Lordship, first, they seized my vehicles, Lordship. Lordship will find.
Taking into account that the matter would require some more elaborate arguments in this matter. Vehicle is with whom?
Lordship, vehicle has been released now.
List this matter for final disposal on 28th of April 2026.
Lordship, may I pray for an early date, Lordship?
No, vehicle has been released. What is there? There's no urgency.
Any date, my lord, as per your lordship's convenience.
28th of April 2026.
My lord, my lord. one order 18/7/25 issued by.
What is this?
Notice has been issued by the Silchar Municipal Board for page 26
You have filed an memo parties, fresh memo parties.
my lord.
Have you filed a fresh memo parties? Why?
The petitioner.
You
is
were
not-
asked to make the
Yes, the
correction.
petitioner is not well, my lord. He's 73 years old, my lord.
Huh?
Petitioner is 73 years old, my lord.
Okay, you file it. We
My
give you the permission.
My lord.
Yes, sir. It is seen that by an order dated 12/8/2025, this court directed the counsel for the petitioner to take appropriate steps for changing the nomenclature of the respondent number 1. Gustav. This court inquired with Mr. P.J. Saikia, the learned counsel, as to why the same have not been done till date. The learned counsel submitted that the petitioner herein is 83 years old. Petitioner?
Hello.
What is the age?
73 years old.
The affidavit is being filed by 39 years old.
Daughter, my lord.
So why you are not doing it to the daughter?
She is a married daughter. Her children, my lord, is facing examination.
Absolutely, this is for 5-6 months. It seems that the petitioner is not interested. We are not interested. Should we dismiss it?
Interested, my lord.
Then
So this pending.
the taking into account that there is no compliance to the order dated 12/8/2025. More particularly to paragraph number 7 of the said order, comma, this court adjourns the matter today and directs the registry to list the matter only after the necessary corrections are carried out.
Obliged.
May it pleases your lordship. Your lordship, where the petitioner number 1 to 7 have been issued sale permission by the office of the district commissioner, Kamrup Metro at Gauhati. Later on, they obtained the land sale permission from the GMDA and also with the deposited the requisite stamp paper and other. But on the date of registration, they could.
Your
come to
sale
know
permission has been cancelled.
Their sale
Yes.
permission has been cancelled.
Why?
On the basis of a letter
It is
issued
seen
by
that
the
after
circle
field
officer.
verification that the government dark number is different from the dark which is in possession. Therefore, it is has stayed for some days. Huh? Who has filed this FTV? What is the reason you have cancelled the sale permission?
The reason we have
Because
been
for
told.
re-verification was done. Re-verification as per our instruction, re-verification was done, but what re-verification, that instruction I'm awaiting, lordship, that I request some.
And who is the respondent number 6?
Earlier also time has been taken and what they have submitted.
Circle officer says something.
They have
What,
after-
what does he say?
It said for re-verification, it has been kept.
With regard to paragraph number 13, the deponent states that it is seen after field verification that the government dark number A is different from the dark which is in possession. Therefore, it is state.
Only that. thing, lord.
Only that.
He is asking for sale permission for what?
Sale permission we have been given. It has been issued in our favor. Then later on it was cancelled.
Cancelled, lord. Because there was some re-verification.
At the time of registration, it was cancelled
Oh,
without issuing us any notice.
absolutely encourages, means this is not done again. State
Lordship,
you
I
are
think
wrong.
for some time, lordship, for where, what
Okay.
reason it has been, we have communicated with.
Many times.
So the
Dates have been
petitioners
taken.
herein are aggrieved by the actions on the part of the respondent authorities in cancelling the sale permissions which were granted to the petitioner. That too without any notice. The record reveals that the notice, that this court by an order dated P-12/2000, when was the notice issued?
Lordship,
Let me
it
write
was
it
issued
here.
on 18/8.
On 18/8/2025 had issued notice, but till date, there is no instructions. And respondent number 6 has filed an affidavit, which however, does not deal with the allegations so made in the instant writ petition. considering the above this matter on 11th of March 2026, a final opportunity is given to the respondents to provide by way reasons for cancellation of the sale permissions which were issued to the petitioner by filing an affidavit, failing which this court shall dispose of the instant with petition on the basis of the materials already available on record. The affidavit has to be filed on or before 9th of March 2026 with advance copy to the petitioner.
Deeply obliged.
Obliged.
This case, affidavit.
Affidavit filed.
Yes, filed by the
Just one more opportunity to file the affidavit.
revenue has filed.
Instructions are already there.
Matter pertains to
My lord, with regard to eviction, my lord, revenue has stated that 4 kata has been allotted.
this is for
Eviction, my lord. Forest department has stated that we have enclosed their land.
Then?
But the revenue department has, my lord, filed the affidavit, and the affidavit stated it was allotted to us earlier.
Anyways, why should we look into it, taking into account the recent judgment of the Supreme Court in respect to the forest land? And we dispose it as per that.
Got it.
You got my order?
The
Hello.
lordship's order, I have not, my Supreme Court order.
No, not my order. I've let the Supreme
Division and shorter.
Forest, yes, Mr. A.R. Bhuya's order. It is site dispose of Kuribo. Give him there shall not be any action taken for unless you are not evicted.
No.
So as per that one. You have been issued notice.
This notice is put to challenge here.
Notice আছে না? Okay, এই notice kon লগাই দিম.
Obliged.
Because madam, keeping it pending makes no sense. Better proceed on your terms. Huh? Yes, what is this?
On behalf of BC, I have received the instruction that there is some communal discourse, so there.
Verbal objection of the district magistrate for performing the Eid prayer on the land. What is this communal?
That's why. And for
They
the.
were having, we are a country which is secular.
Voted in the year 19 something 47 lordship.
Okay. This court by an order dated 13/2/2026 sought for instructions as to whether the petitioner herein would be permitted to perform namaz in the ensuing Eid al-Fitr, which is to be celebrated on 18/3/2026. The additional district magistrate Tinsukia Mr. S.S. Roy have placed before this court an instruction issued by the additional district magistrate in Sukia, seeking some more time to carry out the necessary verification. The said instruction is kept on record and marked with the letter X, taking into account that the Eid al-Fitr is to be celebrated on 18/3/2026, This court directs the respondents to apprise this court by 5th of March 2026 by carrying out the necessary verification without fail.
It is your lordship. Lordship, 3 writ petitions challenging deferment of remission. Challenging deferment of the remission proposals. Petitioners are life conflicts. If on the last occasion, affidavit had been called for.
Lordship, in this case, Lordship receiving.
I have fixed some matters.
Yes,
When?
Lordship. On 20. This is
These
the
are all Morigaon.
No, Lordship, it is
different
from
Lordship, but
different jails.
issues are similar. This is the order. Lordship have fixed them on 27.
27 March.
Lordship.
Okay, let's have these on 27.
Lordship.
Release these matters on 7th of March 2026 along with WPC number 524/2026. The respondents shall without fail file their bring on record their instructions by filing affidavits on or before 18th of March 2026. Liberty given to the petitioners to file reply there against on or before the next date.
Pledged.
Actually, as per earlier order, respondent was directed to file the electrical accident.
Received the report, my lord.
Electrical accident report.
Received the report, my lord. Affidavit.
What does it say?
Contraventions are there, my lord. Contraventions are there, my lord.
Miss, give it to me. Miss Yudas, the learned counsel appearing on behalf of the respondent number 5, na?
My lord, my lord.
Have placed before this court the electrical accident report dated
Please form.
22/1/2026, which is kept on record and marked with the letter X. A copy of the said report is also provided to Mr. B. Chaudhary, the learned counsel appearing on behalf of the APDCL. How much time is there for file an appeal?
One issue, my lord, perhaps
How much time is there for filing an appeal?
it does not specify any time. My lord will give me 2 weeks' time. I'll file an affidavit. There's another issue, perhaps that would require some deliberation, my lord. The petitioner, my lord, the deceased was working with an agent of the APDCL. My lord, there is an agreement in place. The said agreement provides for the safety norms. And my lord, that issue also.
Taking
the
into
agent is not
account the
party.
above, this matter again on 23rd of March 2026. In the meantime, the APDCL shall bring on record their stand by filing the affidavit on or before 19th of March 2026. You take all the
Obliged.
points. In the meantime, you file an appeal, whatever. You give a copy to him.
My lord, right now, I'm.
NS Thakuria, where is she? Yes, madam. Tell me.
Instructions from the deputy commissioner, my lord.
Regarding,
Not received.
shall obtain instruction as to what steps have been taken by the district to the complaint filed by the petitioner, more so taking into account section Iman of the Iman. Okay, madam, we do one thing. This is another thing which you are the complainant.
Yes. Yes, I have already filed complaint. Yes,
You are the complainant. You filed the complaint before whom?
deputy commissioner.
How?
Because my lord, we came to know that.
How can you file the complaint before the deputy commissioner? My question is that. Mr. Doctor, that day in that case, I dismissed one case. There I have looked into it. I have taken another ground for dismissal because the deputy commissioner cannot assume the jurisdiction on his own. The deputy commissioner's jurisdiction is vested in terms with section 111(1)(h), read with section 62, rule 62, 62(4)(b). Now here also the case is how she can file a complaint because the words used out there upon receipt of information means the act or the rules do not give any credence to a person aggrieved for giving information or for pursuing a proceedings other than 126(9). So what they can do is out here, they have no right out here to file this application, isn't it? So therefore, let me keep this, you show that judgment which I have made it ready on the next date and say that my lord is similar. Which one?
This one, the locus.
Oh, no, not necessary. This is a better judgment. This happened 2 days back, na? That they filed an IA
Yes.
where I rejected it.
Yes, yes.
So there, in that, You get the copy of the judgment and then you show it to me, I dismiss her case. Who are you? You should have filed an application under 127. You can 129, not by this manner. Because this will open a Pandora's box.
It has opened, Lordship, already. Already opened.
Huh?
Number of cases are there. pending.
Therefore, that is the reason why that day I got an opportunity, immediately I took over. And this I keep it on that day. When do you want it? So for dismissal? That day also, madam, I said the same to you and I dismissed it. It can be very well routed to the secretary Gaon Panchayat.
No, already he had gone, my lord, but they never did not
The
accept.
DC has no business to look into it.
My lord, no, my lord, as already there is just.
Madam, you have no right.
No.
You have no right.
My lord, as per my lord.
Because the act does not give any right to you to approach.
My lord,
Only right you have been given is under 129.
my lord, may I submit, my lord, on.
Anyways, list this matter when the date of dismissal will be, let's dismiss it on 9th March, not in the first week. Is the matter on 9th of March 2026.
Can it be on 12th, my lord?
Okay, you don't want it 9th. On 12th, too much of
12th?
hearing.
No, Thursday, my lord,
Huh?
or on 13th.
Unlucky day. 30th.
As per telephonic instruction, no such proposal was there to acquire their land. Lord.
To?
No such proposal to acquire their land. Okay.
You have a telephonic. Mr. S.S. Roy, the council submits that he has instructions, he has been informed telephonically that there is no proposal to acquire the land of the petitioner. Of the land of the petitioner or full stop. It is the opinion of this court that the said aspect be brought on record by filing an affidavit. List this matter on 13th of March 2026. So affidavits be filed on or before 11th of March 2026. Interim orders passed earlier shall continue till the next date. What is your name?
D. Sharma, your lordship.
Okay. My number.
This is the matter. Four.
What is?
Yes, 4 KP.
You want
Yes.
adjournment? Why?
No, your lordship last occasion said that if you are
I
not
should dismiss this.
willing to take up this matter, not dismiss lordship.
Have I ever
Yes.
said that?
No, you're not. He had produced an
There is-
order passed by.
Yes,
Justice
I have
A.D. Chaudhary.
produced some order, lordship.
Lordship had completed, go to that court. Try your luck for that court.
Yes,
I said only that.
Yes, sir. Not beyond that.
no, lordship, there is so many order.
No,
lordship.
he says that there was a direction, because that court said that there was a direction to the district commissioner to reconsider.
Similar
Yeah.
petition, your lordship. He has conveyed.
Just for assessment.
In the
lordship.
petition, Justice A.D. Chaudhary had passed an order, he was like, you were supposed to place an order before your lordship. And lordship had said, go to that court, try your luck there. Lordship had
But
said,
unluckily, he's not.
Lordship, kindly see page 104, page number 104 of the writ petition also. There is so many order, lordship. Here is 3 order I have annexed already. And at the present, at that time, my senior also present when order was passed. Here is the order is only page number 104. Here clearly said that as per Telegraph Act, the assessment will be completed and another one is the guideline of central government, lordship. Only 2 things, lordship. They have not denied it at that time. Kindly see, lordship. And similar order passed recently also.
No, the direction is being given to whom?
Deputy Commissioner.
How can
and
the
circle
direction?
officer, lordship.
Once it has been assessed, the deputy
Not
commissioner is.
assessed, lordship. Only the
It's just,
not assessed.
company also, they have received, they have.
No,
made
no,
a
it's some
false
personal
statement
lordship.
in the petition.
Some personal, almost 121 petitioner lordship.
No,
Only-
no, no, 113 petitioners.
Yes, 13, only 25 or 30.
So
petitioners.
if you are sailing with them, along with them, you cannot proceed. It cannot happen. Once it is, no, Mr. Counsel, once it has been assessed, the district commissioner, whether you receive or not, we are not concerned. The district commissioner has no jurisdiction. You have to move under section 15. 16.
16, they have to approach that.
No. And when did it happen?
Proceeds 2014, 15.
Ah, there's no limitation. That is the reason why. Okay, Kerala State Electricity Board.
Yes.
Okay.
Here is the similar order, lordship. So many orders.
No, these orders I cannot follow.
Lordship, I will satisfy and fix.
I'm
it,
not
get
satisfied.
I will satisfy.
It should be dismissed. See, Mr. Das was not supposed to be here. He has come today because of you, isn't it? So you having not filed this court, why should this court exercise? You having lost your time? Because the Supreme Court makes it very clear out there that the Article 137 would be applicable in respect to. In fact, that Kerala judgment is a very interesting judgment because this was the first time the Supreme Court said that by statute an application is to be filed to a court, the Limitation Act will apply. Normally, it would not apply, but if it goes to the court, then only it will apply. Because earlier, there was another judgment wherein says that no limitation applies in these type of cases. But these are 3 judges bench. Kerala State Electricity Board. Yes.
But it's the continue process, lordship.
No continue. There is no continuing.
Started from
No,
2009.
nothing doing.
And till
You
date,
have
some
given time. There are
lordship,
many
in
cases.
the
which
in
have been
some
dismissed.
place till date no connection
Okay.
was given.
Let us have it on some other day to dismiss it. When do I dismiss it? Now keep it in your mind. I'm dismissing it. Okay? So no more taking there. I won't take it up. When? Let's have it on 5th. 5th, both matter, Digi.
11 March.
What? 11. Again, you want to try your luck here. Okay, 11. Let us have it on here. List this matter on 11th at 2 p.m. for final discussion. Yes, what is this?
Made figure of.
Who are you?
I'm a voter and a candidate.
Huh?
I'm a voter of the constituency as well as a candidate who
Then?
contested.
Why didn't you file an election petition?
Your Lordship, under section 111, your Lordship.
They have not. You have written a letter to whom?
The district commission.
Whom?
District commission.
When am I fixing the other case for dismissal?
This one.
No, when am I fixing the
11th
other
of
case?
13.
Huh?
13.
Okay, you also. 13. List the matter here. I got to get a fixed person along with this one. This is
Procedure is given here. Your procedure has been given as to how this disqualification is to be decided.
absolutely no. You are nobody. Because of the fact that you had the option of filing 129. You didn't go there. You cannot resort to backdoor. This is nothing but backdoor politics. We cannot allow these things. Mr. Dotto otherwise likes more litigations for panchayat. It would be more better for him on material instructions. But now also he's getting fed up with this 111 man.
But
Next.
the act itself provides, rule 62 provides that it is the district commissioner who has ultimately to take a decision on these matters.
Should I dismiss it right now? Show me. 62 says that you can file an application to the deputy commissioner.
No,
Show
you
me.
cannot file, but
Then
it is ultimately the district commissioner. Who has
who
to
are
take
you
a
to move the deputy commissioner? You are no business. And if you cannot move the deputy commissioner, and the act says under 111(1)(h), it says it can only be done on terms with section 62, rule 62. It has to be done in that manner, nothing else. In fact, in the morning you said, sir, when I was explaining to Mr. K. Chaudhary this entire. Yes, anyway, we dismiss it on 13th. Mr. Datta, you show it as similar order, not this one, better order. Yes, Mr.
But this applications, I'm not challenging the order that 15/10/2025, your lordship will.
Oh, yes, yes, what has happened?
Plus Mahavir Ekyon.
Here,
What did the trial court do?
the trial court on
Well, I-
16/2, the petitioner side has informed that there is a petition repression pending in the High Court. And accordingly, considering that, the trial court has fixed the case on 2nd of March, awaiting the result of the writ petition.
Hello, we
My
take
lord-
it
my lord,
tomorrow
I
at
just-
10:30.
I just, what my learned friend has said, I have not informed, this is the public prosecutor, they informed that the matter has been, because he is in place.
No, order.
I was there, I was there.
Order is with
So
me.
why I'll say before the court?
No, order is with me, my lord. I have the order. In fact,
Irrespective
No,
of
what
that.
am I,
See,
I am
you-
not there.
no, the
The only things what my,
Mr. Pramgura, let me also say,
well,
irrespective of all that, when a question has come up before this court will decide. You get an order from the court, it's a different thing. That is another ballgame. You can get it from the trial court in the meantime. But the moment the matter comes up before me, I will see on the constitutional point of view as to whether you are empowered to seal or unless it is, if you take it as a proceeds of the crime, because this has to be a proceed of the crime.
Well, in fact, these are the we have in our affidavit, we have said that he is the prime accused and this is the, after my lord investigation, we found that the amount invested has been accrued from the money misappropriated from his employer.
So it's a proceed of the crime.
And
If it's the proceeds of the crime, you have to follow the Prevention of Money Laundering Act and go for adjudication under Section 5, get it attached, and then an adjudication under Section 8. Not this manner. The trial court doesn't have the jurisdiction to do that. Neither the police have the jurisdiction if it is a procedure. Because the word which you are using is exactly the meaning which is assigned by the PMLA Act out there. Go ahead, do whatever you need as per the PMLA Act. And this has to be done by the NIA, not by you.
Section 107 also, my lord, gives us power, my lord. Section 107 of BNS as well.
What does it say?
It gives us power. Attachment,
Sure.
section 107,
BNS
attachment, forfeiture or restoration of property.
BNS Act also. BNNS. Double NS. What does it say?
Well, it says 107, attachment, forfeiture or restoration of property, where a police officer making an investigation has reason to believe that any property is derived or obtained directly or indirectly as a result of a criminal activity or from the commission of any offense, he may, with the approval of the superintendent of police or commissioner of police, make an application to the court or the magistrate exercising jurisdiction to take cognizance of the offense or commit for trial or try the case for attachment of such property.
Make an application to the court. With the approval of the make an application to the court or the magistrate exercising jurisdiction to take cognizance of the offense or commit for trial or try the case for the attachment of such property. If the court or the magistrate has reasons to believe whether before or after taking the evidence that all such property are proceeds of the crime, the court or the magistrate may issue a notice upon such person calling upon him to show cause, so and so. You cannot attach it.
No.
How do you attach it?
Well, that notice has been issued. They appeared. They
No,
have
no,
told me
how
that-
do you attach it? Where is your power to attach it? The power would be, if you see, of the court at best.
my lord.
The attachment on this basis.
And my lord, just a small one. Lordship, in BNSS, my lord, the proceed of crimes has not been defined. Proceed of crimes has not been defined. But in PMLA, the proceed of crime has been defined. And so for the proceed of crime, so for the BNSS is concerned, my lord, you can see the definition, my lord, there is no definition of the proceed of crime is concerned.
After considering the explanation, if any, to the so-called notice issued under subsection 2 and the material fact available before such court or magistrate, and after giving an order of being heard to such may pass an order of attachment. The order of attachment will be passed later on. Now here is the case, you have attached it. How do you do it?
Well,
We set aside this.
Logic may take up tomorrow.
No, we attach, set aside. This type of matters cannot remain.
Kindly take it up tomorrow, my lord.
That to October, my lord, I have to pay installment,
My lord,
bank
indeed,
installment.
during investigation, when it's revealed, my lord, when it's revealed, ultimately, my lord, that has to be, otherwise, the property may have, he may have liquidated the property, my lord.
How, take a
Till-
bone?
Till the order is passed.
I have
till
a
the-
loan of 3.2 crores, my lord. Only thing
We
is,
do one thing, we stay this attachment, taking into account that it is only the court who has the power.
my lord,
Section 107 petition is pending, my lord.
No,
till the order is
but
passed.
how can you, why should this court allow this thing to continue for 1 minute when this transgression is noticed, comes to the attention of this court? It is apparently clear that you say that it is done under 107. 107, one says that, look here, it can be very well done by only after taking the approval from the superintendent of police, then to file an application before the court will issue notice, and after doing all this thing, giving him a reasonable opportunity of hearing and explanation, then can pass an order of attachment. That is what has been mentioned. Now, therefore, this having not been done, that is the mandate of law. How on earth can you do this? No. But this is high time. I think we should set aside this
Lordship
type
may
of things.
Consider the 107.
We have it
petition
tomorrow at 10:30 and
But-
finish it off.
Tomorrow at 2.
10:30, we finish it. This type of matter cannot be allowed. And irrespective of the, we set aside, but that will be subject to what order they may pass. They may pass any order, that is a different thing.
Petition is pending.
Maybe, but that has to be done as per law. List the matter tomorrow at 2 p.m.
Not
filing dispute. Yes, we have been informed that the housekeeping has in the meantime increased.
Yes, my lord. Some meeting has.
Before.
Some meeting has been held, my lord, and some meeting has been held, and the minutes of the meeting, your lordship will have. What happens?
Page of that one. Okay.
1.5.
Notification 13 to 26.
24th February.
No, 13 to 26.
13th February.
One month. Yes, yes. Copy and yes.
This is for 2026-27.
That is for this course of account that I can use. If you go to 24th, this. Budget account for 26-27. 60. But this is the is the financial year. Particularly, this is 21 to 24, 26. All time to come. All time to come. Next thing.
The company are requested, they will set to 5, including the and requested them to. Request first.
So 24-25, there is a drastic reduction.
Yes, sir.
By around 60 crores.
Now that is why the
70 crores?
difficulties.
Yes, compared to 23-24, that I also observed.
So drastic reduction. Why so? Now this 26-27, which you are asking for 61 crores, this is for the interim budget. Is this the interim budget?
Yes, yes.
Or because there will be a post-election another budget?
There will be regular budget.
There will be regular budget. After
This is the interim budget.
Interim budget. Okay.
Now tell me one thing. Out here, you are saying about infrastructure. Does the High Court building is there in the new building?
No.
Under this budget, High Court building?
No, it's not there. It's not there. Separate.
On what account then? What is that account then? Because that is also an infrastructure account of the High Court. You have put it as an infrastructure of the High Court.
That maybe perhaps will be spent from the global head.
So this is not global head.
This is not global head. This is not global head.
And how do you get the money to the global head? Unless it is put in the budget. How is it possible?
Beyond this, is there any provision for the new High Court building in a separately budgeted?
Separately budget. Separately budget.
So this is not included.
It is not included here. Here, my lord. Yes.
Okay. But how are you putting it on that aspect? Just for example, a separate head, because you are putting this in the Gauhati High Court infrastructure.
Maybe because it's a major project, so maybe because of that.
Separated.
Because it's a high
construction, not for that.
So now tell me, in these budgets which are being given out here,
my lord,
you are having the 10% on the CSS projects?
Yes, yes.
So therefore, do we need to understand like this, that whatever budgeted for say suppose the some year 23, 24. These are the state allocation. There are some constructions where 90% will come from central government.
Central government,
And
yes.
10% will go from
State government.
state.
Yes.
These are
So
the,
whether these
Yes.
10%
These
is
are included.
or including the 90
These are included, my lord.
in,
These are included here.
no,
10%.
90 is not included.
My lord, the SOPD budget. That allocation, lordship will find the head is mentioned against separately 23, 24. If your lordship take the budget, the SOPD, these are the state funded budgets. And CSS are those projects, my lord, where the central government is spending the amount.
So
Those
these
are
are
CSS projects.
This CSS is only you are giving this budget, or are you including the central government portion also?
15, lordship will see serial 15.
Ah.
This is the central part. Then immediately 16 is the 10% probably of the state. So that's why my lord, back to back it has been mentioned.
Where? Oh, this is the state.
Yes, 15, 16. CSF is the my lord, central share.
This is their 10.
Yes. 10% state share, that is 16. Same 17 and 18. my lord.
It is state share. It is state share.
So therefore, money against serial number 15 is not of state money. This will come from central.
Yes.
Serial number 15.
Yeah.
Only serial number 16 in relation to serial number 15 is given by the state.
And 18.
Maybe because I'm giving
16
you
and
one
18.
example.
Our
15 and 16.
Yes.
So how can you say that we have allocated so much? You'll have to minus this 5040 from your.
Ultimately, budget will be routed from the state. level.
You will get
The state,
reimbursement.
Central will provide to the state, level, then it will go to the.
So that's why I'm saying, we want
Yes,
some
that's why
more
it will be-
contribution independently from you. If we go by that, then it gets reduced more.
No, in fact, why it seems so? Now, just for example, come to 23, 24, 25. This is 5040 again. Okay.
Yes, ma'am.
This is the state. So that is here the center. This is the center. The state has not put its portion.
For the year 24-25, come to serial number 15. This is CSS. Where is the count CSS SOPDSS?
It has been made 190 and 10 is the contribution of state. Central is 100, total is 100. Central is 90,
They
total
are
is.
showing us a very bright picture that I'm giving you
But actually
200 rupees, but actually they are giving us 110 rupees. 90 is coming from central government.
No, I don't understand, because if you are putting it as infrastructure for the High Court, see, I prefer project heads of the accounts of the Gauhati High Court and the District Judiciary of Assam. This is the head, Annexure A. You have put it. So why the new building of the High Court, which you are proposing to construct, where it has been announced that there is a 1700 crores would be the expenses. Is it budgeted? Why I am saying so? You see, just for example, recently, if you see the central budget which has been placed. In the central budget, it is being placed that they have put it around 5 lakh crores for the purpose of making the various high-speed corridors. Now, these 5 lakh crores which is being made is not going to spend on now, of which certain allocation is being made for this present year. Remaining will be given in subsequent years. But these are all which are think on future. Are these things are these put in the budgets or not in the state? No. Without knowing it, you are saying.
Well, we'll have to take instruction on this. I think it will come up in the regular budget, my lord.
No, therefore we asked.
We're telling you one thing. Come with all information. Because we cannot adjourn a matter. You must be ready with your questions. It's like our lawyer is arguing, we ask him a question on fact or law, he'll say.
Alright, if I may submit, my lord.
adjourned. And next day we'll ask him a different question, he will get it adjourned. This cannot happen in this special.
Because this is my lord, the technical thing, the finance commissioner.
Bring someone who can
Yes, my lord.
properly assist you technically.
Mr. Chakraborty, why we are saying there is a reason why.
Yes.
What is happening out here is this. We have around 382 priorities projects which all of you have looked into it. Yes, there are 382 projects which are on a priority. Remaining projects may not be of priority, but then also out of that there is more priority. Now, when you are asking, you see the building committee out here, which is dealing with it, they are looking into various aspects. Are they therefore not required to know? Because you see, you cannot equate the High Court or the judiciary as a department of the state. We are independent of it. So being so, although the finance is being provided by the state, we also require a budget. We should also know that where we are going to spend this year. And when we say that we are going to spend this amount of, these are the things on which we are going to do it, we will then only we also keep in our mind that look here, these are the projects which needs urgency. Small projects, like small things like just for example, some whitewashing is done. This can be done in some under the smaller accounts. But when it comes to bigger accounts, you don't just, what is happening out here is, as we notice, both of us being 4 years down the line in this profession as a judge, on the administrative side, what is happening whenever a project is being floated out there, we just said approved.
Yes.
Without commenting on the cost factor. But it remains like that.
That's why so many 500, 600,000 projects.
So therefore it keeps on going it. But don't you think, which we also think that we need to have a budget. We should also have a budget to the effect that these are the things which we propose to do. And for that seek allocation to be put in the budget of the state, if the state is paying. And if there is an amount which the center would also be paying, that also to be taken note of. Now, what is happening is, we do all this thing, matter goes out there before the government, and it becomes a discretion of the government whom to give whom. This cannot happen like that.
That has been happening.
The priority which is there has to be understood by the court on the administrative.
So far, my understanding, my lord, having seen things closely a little bit, my lord, it has been happening like this.
No, why it is happening? See, for us, for the infrastructure committee, all projects are important.
Yes, ma'am.
Okay, but we are not aware our limits. We must know that in this year, we are having 100 rupees. So we have a demand from the different high courts, 200 rupees. Then we'll prioritize that these are important. So we'll send them only. Now what is happening is, whatever comes, we think this is important, approve and send it to. Now who will decide that which is important? So it's a pending like anything.
Yes.
So before we recommend or even a proposal, we must have the knowledge that this is the amount we can spend. Then suppose we have already made some proposal that this is amount. Then for the next, we must know that already this is sent only left with 80 rupees. So we'll now think over among this 80 rupees. Then suppose we give another 50. Remaining is say 20. Then also we'll incorporate those most important programs. But as on date, what we understand is we are not aware what is our limits. So we are sending proposals like anything.
This can be implemented.
Just for example, let us give also the example of a state.
Yes.
Can the state buy a budget, whatever they feel like? No. They also know that you see, our receipts would be this much. our expenditure would be this much. These are the capital receipts. These are the revenue receipts. And as such, this is the amount we are going to spend this much, and there might be a deficit budget of this percent. This is how a budget is being prepared.
Certainly.
Now, what is happening is the same philosophy has also do. Yes, the state is going to pay. Now, how do we'll do it? We say that the state, we have asked the state this amount, and we are likely to get this amount. And on the basis, this is the expenditure which is going to happen. There's another aspect of the matter. Just for example, if you see 229(3), all employees of the state, of the High Court, are to be paid from the consolidated fund. So whatever is their salary out there has to be charged to the consolidated fund. The salaries of the judges also are charged to the consolidated fund. So in view of 204, that cannot be touched. So that is another aspect of the matter where we need not worry, because that is the burden upon you, where you have to fix it in your budget that these are already marked to the consolidated fund of the state. Just for example, the finance department persons, the director or whoever it is, their salaries, these are all being categorically mentioned in the budget that this is the salary which is to require. But when it comes to infrastructure, we have to know how much you are giving us and how much we are going to spend. It cannot happen. Small aspects like some. No, therefore, there needs an overhauling of that. Mr. Gogoi also, you have to see. Just for example, here you have put it that 1.5 crores provided you use the gem. Now, the problem which is going to happen with the gem is that the amount which will go up will be huge. We are, if we are not wrong, Mr. Register Administration, we are engaging the Sulabh thing. They have a particular, is it done through the gem?
No.
Now you have put this as gem. The problem which is, it will go up. Are you, for your housekeeping services, are you having it through the gem? No. Because this is, you see, for purchase of utensils, purchase of certain equipments out there from gem is okay. But for services out there, if it is not only it is going to, it will have a huge, you are asking these service contracts to be given on the basis of gem. And there will be a lot of big problems which will may ensure all these persons have to be now in view of this. They can't spend a single penny. Kindly see this 1.5 housekeeping, which you have put, is as per their gem. How will they procure it through gem?
Spend the money. The condition precedent.
It will have a far-reaching consequences now. Now this price will go up. So those contracts gives liberty to the, I hope that Gauhati High Court would have, you have the liberty, they will engage those persons within that parameters, but you putting it. Yes, for the purpose, just for example, you for housekeeping, you need to buy these phenols and all these things. Very well, they can purchase it through gem or whatever it may be, they do it whatever it may be. But if you put it, now going for gem for purchasing phenols up there for the High Court, it's okay, because this is the High Court is a bigger one. But what do you say about the district court out there in Dhemaji? Do you require it from gem? It will amount to huge amounts. So these are things which needs to be taken or introspected, because now it would be very difficult for them to use it. You have put it, you have increased it, but the fact remains you have this problem which cannot be. What do you say, Mr. Sinha, who is there in the finance? You will be better off to tell me.
Yes, Lordship.
Come to the area.
Lordship, district may not be this much technically, equipped to think the part. Majority it is Lordship available. Gem service is available. Some remote district may have some problem. Lordship.
Because you have, while putting that cap of 2 lakhs, you never put the gem thing. Why have you put the gem here?
It has been evolving thing, my lord. The DFPR is not very old, my lord, 2022 only. It has been. So
No, why have you put the gem?
Probably government wants to put one portal so that to stop the pilferage of fund, my lord, so that contracts are not awarded whimsically, arbitrarily. To make some uniform things, my lord, I think JAM has been brought. It is applicable across the departments.
Suppose what will happen to the pending dues? We have already engaged a contractor. Now dues are pending. That money will now be released. Now.
So
if you
far as
say-
the sweeping things are concerned, outsourcing, we have requested the finance department, whatever the outstanding, so far as the district judiciary is concerned, to put them as a extraordinary measure, one time, to give away.
What
with the-
about High Court? That pending?
And also High Court equally. And so far as the new financial year is concerned,
সুলভ পাই আছা যদি শুরু হয়ে গেল যে আমাকে কিমান টাকা দিয়ে নহলে কাম নকৰো মনোপলি হয় নেকি আজি সুলভ সুলভৰ পৰা মোক 100 টকাৰ জাগাত 500 টকা লাগিব নহলে কাম নকৰো
JAM is registered by the government.
Mr. Register Administration, tell us one thing. How do you allot the contract for cleaning out here in Gauhati High Court?
Lordship, it was negotiated and placed before the Honorable FABC, then it is approved and it is actually from 2013, I think, this contract is continuing with renewals. So,
I think this not in right spirit to put this.
We should have given a liberty.
JAM cannot be there.
See, we have a Mr. Gogoi, we have a special committee looking into all these supplies and all. They approve, then they call some limited expression of interest, then they negotiate price, decide. Your purpose will, as a high court, I think we should, it should be excluded in case of JAM. Suppose we want to buy a pen, then also, because we have some our enlisted suppliers in many cases. So suppose we want to buy, say, some air conditioners or something like that. Instead of going to them, we'll call these 3-4 suppliers that give your prices. Amongst them, whichever is, and we'll compare it. We may compare with the price of JAM. Then we'll negotiate.
And all these things are done as per JAM portal. There's not yes, the price is given as per the JAM portal. There's nothing to that effect. It is not given. But the fact remains out there that the moment you are putting this, in fact, this creates a more hurdle. Earlier it was not required. Now you have put this JAM portal out there, which means that it becomes next to impossible. This is not properly done.
Here we are getting the Sulabh thing.
Not only Sulabh, in other cases also. Suppose we want to buy a pen, pencil, you'll have to go through the JAM. Then it's very difficult. Suppose you are given defective things, you cannot, at least we suppliers, our registered suppliers, we can say, no, we are not accepting this, return it back. We have done this.
In case of AMC also, Lordship, the agency fixed a renewal rate and those rates will put before the FABC special committee.
FABC, there is special committee finance.
Our committees will be meaningless then.
No, that independence to the High Court. Don't treat us as your department, creating doubt upon their officers. They may do this, they may do that. These committees are headed by some senior judges. Administration is there. I think that you
have
cannot
a
equalize with these departments like.
You cannot have that. This touches on the independence of the judiciary, basic feature of the constitution.
Yes.
Make some observation in the order, I will convey. Yeah, only on this part, the JAM condition.
Mr. You, both of you should have said to us, we have to find out by ourselves.
No, we discussed. I raised this question that this GEM thing will create problem. Then, Milord, I was told that GEM is, sorry, Milord, this.
Yeah,
Sulabh
out
level-
here, in all other departments, you get it through GEM.
Gem, yes.
Gem.
Because
It
there's
was
some
introduced
notification-
last year, Malad.
Huh?
There's some notification of the finance also, but that have to be through Gem.
No, not purchasing, housekeeping. Are you getting your people working in the finance
Yes,
department,
madam,
the
yes.
cleaning staff, to GEM?
Even secretariat also, Malad, people are working through GEM.
Okay, so how do you do it?
Tender.
No, how do you do it? Because this is an important thing. If you can get it, we can also get it at a cheaper price. It is very good.
Yes, Malad.
But how do you get it?
Malad may give some time.
Because I think, if I'm not mistaken,
Yes, madam.
in GEM, there are registered suppliers for
Yes.
specific things.
Yes.
Then you'll have to float the tender that we require this. Then in the GEM portal, all these, those registered in the GEM, they will participate.
They will
I think
participate.
Sulabh is also registered in
Yes.
GEM.
Yes.
Now, amongst them, the authority that FMVPC or whatsoever, they will select that this should be our supplier.
Look, as of date, Sulabh is not registered. So for my instruction goes.
Maybe different.
There is another problem. If tomorrow Sulabh says that I am doing this for 100, tomorrow you give me 500, then we will be optionless because it is only the Sulabh.
Not, we are not going to the Sulabh to that extent.
No, no,
now.
I'm just
I am
putting an
understanding
example.
I'm understanding the procedure. Is it this procedure?
Well, in Gem, it tenders are issue. Like,
Tenders are
like for interest
GEM is a general government
It's a portal.
e-marketplace.
No, e-market.
E-marketplace.
There are several registered suppliers are
So
there.
tender, we can issue the tender. Anybody can issue the tender in the GEM portal.
In the GEM,
Only
Malad,
participants will be those who are registered in GEM.
yes, Malad. Even parties from outside the state are also there. They are supplying, Malad. That is also there.
We do one thing, we have it again next week out here. You just find out, because we would not like to comment on this, because if it is otherwise beneficial,
Lordship.
then let it remain.
Right.
But only thing is, whether it becomes too difficult, that is another thing. Although we may say, because you see, you have also a notification to the effect, the Assam Public Procurement Act. Assam Public Procurement Act will also apply to us also, taking into account that is the act. So there it says the above a particular amount has to go by way of a GEM portal. If it is more than 10 lakhs or something, isn't it?
50 lakhs something.
50 lakhs. But if it is less than that,
Well,
just for example, we may have to ask for the entire district judiciary. Then only it may come to.
There-
Malad,
Malad,
if there is a deviation, Malad, the finance
No,
department
that
has
is
to be,
central.
concurrence will
portal.
be
There is-
necessary
in
in
the
that case.
central portal, state portal, there is another portal.
There is another portal.
Yes. There-
The state is what?
Well, I don't remember the name, but there is a.
No, that also we are aware that they have a state portal.
Yes.
So why you are not putting it also the
The
state?
state,
Then, yes.
Why you are putting it
case
in
of
the
Malad
GEM?
Below the 50 lakhs or so, then Malad, at least that option can be. Malad.
If this is being given in SEM or so and so,
Yes, yes.
then also it is good.
But
Because
the
you-
notification will Malad cover that part. I placed the notification on the finance department. There it has been clarified, even though it has been notified to be GEM. If it is below a particular level, then Malad, it can go for a different Malad mode of.
So you
procuring.
produce that.
That will help Malad.
You produce us that, and
Yes,
another thing is, how is it happening out there?
Lordship.
Means how are you? Just for example, in the finance department.
Malad.
Now in the health department, you are having you engage your own. Now in the finance department, how are you taking care of the housekeeping, and how much expenses are being incurred? This is a very
Can
important
be
thing.
taken for the
Then we
secretariat,
can
entire,
understand that if it is
For the
less.
entire secretariat.
entire secretariat building can be
Okay,
taken.
secretariat, and how many people are engaged? This is required. How many people are engaged, and how many and what is the amount that has to be paid for that? Because then we will know that how much we are spending out here, would it be right or wrong, or instead going for
Compared to
GEM would
the-
be more beneficial.
but if in the
For my-
meantime, we have engaged them through FMVC, then they have spent their money, we have committed them. Then for this release of money, them cannot be imposed.
The amount of,
That is not the purport of this particular condition. party who is already continuing. For that, it's not required for
That
that.
is, they will have to make.
Yes, that, no, that's there, my lord. For my lord, new purchase.
For the new
Then,
purchase.
Yes.
So far, my personal knowledge goes, my lord,
Then allotted.
the
Allotment
amount,
will have to be fresh allotment.
the amount spent for the, I mean, secretariat is much more than that is done for the High Court, my lord. The amount spent for the secretariat maintenance is much higher than.
Maybe we are want to understand the system, how
Yes,
it
madam.
is operating and what is the benefit, pros and cons, so that we can apply our,
We'll apprise, madam.
whether that will be a beneficial for us to apply this system to an institution or with this footfall and this kind of requirement within this High Court or district judicial. That is what we want to understand.
Because otherwise what will happen is, yes, but if it is in the in the secretariat, in the JAM it is 100 rupees. And in 100 rupees, you are getting 20%, which is 5,000. It's an example. 5,000. Now, out here, in 100 rupees, if we are getting 25%, then it makes no sense for us to go for JAM. But if it is so, because you have to also understand certain things you cannot impose upon the High Court. Otherwise, it will have an independence of the judiciary. But on the other hand, if it is found that yes, the benefit is comparative or it is equal or better, obviously, this going for JAM would be a better option.
Certainly.
So this clause can only be analyzed on the basis. Whatever we are saying is we are just analyzing. Neither both of us are not an expert on this. Mr. Gugoi is an expert on finance. It's a different thing. We are not. Huh?
I depend on interest.
So he is there. Okay.
That instruction I can help.
Oh.
Now we'll have to, next state, we'll have to move to the other things also.
Oh,
There
next
are
date
things
we are
that
moving
we
because today
are
again, yeah.
confined to this only.
Next date we are moving on the Chief Judicial Magistrate.
Today I called up for this, my lord, they said that, my lord, so far as the shifting part is concerned of the tribunals, that has been done. Their part has been, including furniture, all has been allotted. So subsequent development, my lord, they prepared a plan, because on the last occasion when Lordship has visited, Lordship has advised regarding the size of the rooms and all. They prepared a design and it has been placed before the CJ. Just to make some comments on that. Subsequent to that, my lord, I don't know.
If you can
Today I-
place us
I will
the,
place a written form.
yeah, you place us on the next day. When can we can have it next week? One. Yeah, আগৰ সেই ফাৰ্ষ্ট লাইনটো লিখি দিব হা বিশ্বজিৎ চক্ৰৱৰ্তী আৰু এয়া মোৰ নিচিনা আছে এলাৰ্জ Pursuant to the order passed by this court on 10/2/2026, comma, Mr. Mr. B. Gogoi has placed an instruction dated 24/2/2026 issued by the Secretary to the Government of Assam Finance Establishment Department, wherein the notification dated 13/2/2026 have been thereby bringing to the notice of this court the notification dated 13/2/2026, whereby the extent of power have been given extended up to 1.5 crores per annum, but subject to certain conditions mentioned therein. So, we have deliberated on these conditions, and we would like further instructions in that respect, which Mr. B. Gogoi, as well as the learned additional advocate general, as well as Mr. B. Chakraborty, the learned LR, shall place on the next date. We have also taken note of the various amounts which have been provided on the infrastructure head of this court, as well as the district judiciary of Assam for the financial years 2020-21 to 2024-26. 24-26. In addition to that, a minutes of the meeting dated 23/2/2026 have also been placed before us, wherein various resolutions have been taken various resolutions have been taken. Amongst the various resolutions, one of the such resolution pertains to the request made by the Gauhati High Court for removing the capping limit in the DRF rules.
DEFP.
D?
DEFP.
DEFP. Rules to issue financial sanction, which the finance department have assured the registry of the Gauhati High Court on the to discuss with the competent authority for the smooth and take necessary decision for smooth functioning of the judicial courts all over Assam. List this matter again on Astari. Stake another one. Astari. Stake in the detail. I think we single wins. On 5th of February, March 2026, for further hearing, this court would also bring it to the notice of the learned counsels who represents the respective parties, that on the next date we shall also take note of the present that we should also be informed as regards the present status pertaining to the shifting of the CGM Kamrup metro establishment.
One of the rule is DFPR rules. DFPR rules 2022. My lord, can it be, may I just make a request? Can it be in the next week, my lord, because there's Holi in between, my lord.
Well, my lord.
Okay.
Because Saturday,
Holi is over on 4th.
No, it's okay.
my third, fourth,
Third,
and
fourth.
28, my lord. Only 3 days.
Holi.
my lord.
They
Only
also
1 day.
like to take the advantage because chief is taking.
12.
Yes.
Okay. Let it be on
12th is
10th.
fine.
10th.
10th. Yes, 10th is
10th?
fine.
10th.
Fine.
What is this Kohima bench? Where is it? Oh, yes. Yes.
Please, Lordship.
Have the affidavits been filed?
Lordship, so far the 4 court martial has been sanctioned.
Has the Advocate General last time has given us some assurance on 2011-2025 that a matter would be discussed in the cabinet? Has anything happened in the meantime?
Yes, so far the 4 court martial boss has been sanctioned.
Itu ikut. Kenapa sini? Itu kenapa ni?
Lordship, am I audible?
Yes, now a bit. Yes, what has happened? The matter was to be placed before the cabinet.
Yes, so far 4 court martial boss has been sanctioned.
4 persons.
Yes, court master post, 4 post of court master.
Okay. And how many posts, Mr. Jameen, you were asking for?
Our requirement is many, but then as of now, the cabinet in the last sitting, they have sanctioned 4 posts of court masters and few posts of MTS, multitasking posts.
Okay.
But then again, some fresh proposal have been submitted for creation of extra post, and that is under active consideration of the government, so far as my knowledge goes. My learned friend will be in a better position to know, but then that is my information I have received.
We do one thing, Mr. Im Song. Put it on affidavit as pertaining to the 4 posts and the other posts which have been created in the meantime, and which are under active consideration, so that we can deal with it on the next day. We give you in this matter, we adjourn this matter to be taken up after another 1 month.
The other matter has been fixed on 10th, Lordship, in case of Assam. So
That is on 10, but 10 to not, he can file the affidavit by 10, by 8th, in 6th or 7th. 6th you can file the affidavit.
Yes.
1 week you can very well file the affidavit, just bringing on to the notice what has happened till now. And thereupon we'll take it, what has happened.
Was it progress?
Progress, it is just a progress which we are looking into it.
Positive.
It's a very positive development. Convey our regards to the Advocate General. Okay. It has been informed to us, heard Mr. C.T. Jamir, the learned senior counsel, appearing on behalf of the petitioners, and Mr. I. Im Song, the learned additional AG, Nagaland. Full stop. Pursuant to the submissions so made by the learned Advocate General Nagaland on 20/11/2025, it has been brought to the notice of this court that certain posts have been created in the meantime, and further certain posts are under active consideration. It is our opinion that the said aspect be brought on record by filing an affidavit on or before 6th of March 2026. List the matter again on 10/3/2026 for an update.
Obliged, Lordships.